Well, we got my cough on the,
Yeah,
on.
we just start, I want to.
Ready? Would call to order a regular council meeting on this Monday, February 26, 2024 at 2 p.m. Could we stand please for the pledge to our flag? Councilor Baber, would you lead us please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. We get a roll call, please, clerk.
Counselor Miller,
Here,
Counselor Proctor,
Aye.
Counselor Lakeland, here, Counselor Baber,
Aye.
Mary Rutherford.
I'd entertain a motion to approve the agenda.
I'll make a motion to approve the agenda except for A. I want to postpone, I have F, I'm sorry, not F.
All right, let me find that, please. Oh, okay, that's, yes,
That's for the beautification committee, our bylaws. And we didn't get it finished. We met just for a short time, so I want to postpone it till the last meeting.
that would be
in
March 25th council meeting.
Yes, if you will.
Yeah, I was just told about that about 8 minutes ago.
Okay,
So,
it's F on new business.
Council Miller wants to postpone that to the March 25th
25th.
council meeting. Give her time to have a look at all that information.
And all the rest of the committee.
Oh, we didn't get a second again. All right, I'd entertain a motion to approve the consent agenda. And that takes us to public input. Do you have anyone who wants to address the governing body at this time? Okay, councilors' comments. Councilors,
I'd like to make a comment.
yes.
I move that my statement be listed verbatim in the minutes.
Second that. I didn't hear what you said.
I move that my statement be listed verbatim in the minutes, and there was a second. Counselor Baber, we're voting whether or not my minutes to be, and my statement to be.
Oh, aye.
Counselor Miller,
Aye.
Counselor Proctor,
Aye.
Counselor Lakeland. Aye. Motion carried. Good afternoon to the citizens of Rio Downs. New Mexico State Statute 311(5) states the governing body fails to confirm any person as an appointed official or employee of a municipality. The mayor at the next regular meeting of the governing body shall submit the name of another person to fill the appointed office or to be employed by the municipality. At the first city council meeting of this governing body, during our organizational meeting, under the above stated statute, we did not confirm 2 appointed officials and 2 employees of the municipality. Essentially, that means that 2 weeks later, on January 22nd, those 4 individuals should have been replaced, and they should no longer be working for our city. I researched the word statute and found it clearly stated that a statute is essentially a written law that is enacted by a legislative body, such as Congress or a state legislature. It is a formal rule or regulation that is codified and recorded in the books. Once a statute is enacted, it becomes part of the legal framework of the jurisdiction in which it was passed. Mr. Underwood told me that shall is a mandatory word for a discretionary act. He was kind of saying the mayor doesn't have to do it. I maintain that putting the mandatory word shall in front of a statutory requirement makes it incorrect. This mayor has had 3 opportunities in 2 months to obey the law, but he has willingly and knowingly disobeyed the law. And I'm thinking 3 strikes and you're out. As a governing body, what we're trying to do is what we were elected to do for the good of the city. And we have heard what the citizens of Rio Downs want. This mayor is intentionally breaking the law, and is continuing to be negligent in fulfilling his oath of office by acting contrary to state statutes. We must take the next step, a legal step, to see that he is accountable for his lack of action and refusal to obey the law. Amen.
Any more, comments, counselors? Yes, sir.
Last Friday, I guess, we were supposed to have turned in our list to get on the agenda, and it didn't get out to everybody. So I came in, I think it was that Monday or that Tuesday, I'm sorry, and spoke with the city clerk and agreed to that if the holiday falls on a Monday, we can't get it turned in on Tuesday, we turn it in at 10 o'clock and let her have an extra day, just like we would in a council meeting. Just moving on. And she agreed to that. I don't see no reason for us to put it on kind of resolution or anything. I just want to let the rest of the governing body know and the audience know. When the holiday falls on the Monday that we're supposed to turn in our, it will go to Tuesday. And she'll have Tuesday from 10 o'clock, Wednesday and Thursday, and put them out sometime Thursday afternoon. And that's still earlier than what we were getting them.
Okay, thank you.
Mayor, I have one comment.
Yes.
It's mostly to John, our attorney. And I stated at the last meeting that we're all interpreting our state statutes and our ordinances differently. And John did call me and he said he would get a workshop or a special meeting together with somebody from Municipal League to come down and let us all talk about this. We are a team. We need to have teamwork. We need to know our statutes and we need to know our ordinances. And not just the interpretation of someone else. We need to know directly what they mean and so we can work better together. John, did you get anything done?
I did. I talked to the director of the municipal league on Friday, and he has agreed to send a mediator down to meet with. I said we have a dispute between the city council and the mayor, and that we need to sit down and talk, go through the statutes and ordinances, and see if we can work through these things. And as you probably know, they just finished with the legislative session.
Yeah,
So he had been pretty busy. He said he had the best legislative session he'd ever had, which was good to hear on behalf of municipalities. And that he would be getting back to us or have probably Gino Zamora that mediated the issues between the city finance director and the city judge down, making an appointment. He said it would probably be a month or so before that could happen.
well, thanks for following through.
So I urged him, I told him that we needed help and would appreciate their help.
And communication's a key to all of us being able to work together and come out ahead. Thank you.
A good example of that is one reason they had the best session they've ever had. We have a tremendous state representative from this area and he can work with anybody if they'll let him. He's really outnumbered in Santa Fe. So encouraging. I started from that months and months ago. I told him, said it's gonna be tough up there because you're in the minority by far.
Mr. Mayor, just in that regard, I talked with Representative Vincent during the session. I carried our list of capital outlay requests to him, discussed those with him, talked to him about our priorities. And because he had a situation of one of his constituents, I think it Enchanted Water Company being totally out of water, that he was having to send a lot of money to them. But he did agree, and I haven't gotten confirmation. I don't know if you have, Joy, of total funding for the slash truck that we were requesting, which was some $250,000 or $260,000.
Also, we're getting some new police vehicles. That's one reason that I sent Councilor Weber up there to use his influence with the state. So I believe we're getting 6. Is that correct,
Three.
Three, okay. Thank you, for that.
And a big truck for Joey.
Beg pardon?
And a big truck for Joey.
Okay, so that was a worthwhile trip up there. Okay, monthly reports. Joey, let's just get it over. Let you suffer through, your allergies, and if you're like I am, the more you talk, the more you cough.
Pretty much. There you go. I got a lot more. Thank you. For the month of January, it's pretty basic report because of the holidays and very short staff that time of year. All the projects are still in the same state they were last month. We're waiting materials for East and West Circle. Valley View project is in design. The asset management plan is now we're working on that. I met with them last week. South Central Road, we had to do a pivot on South Central Road. We were gonna pave it this summer, but with the funding for the East and West Circle project, there's not enough money to pave. East and West. So it's gonna have brand new water lines, fire hydrants, curb gutter, and no pavement, because the cost of inflation. So I'm gonna take the money, I've already started the reallocation to move the money from South Central to finish that project. And I'll apply for South Central again this year. We need to finish it and not leave it half done. Harris Lane is in design. There is the 500,000 for the design of City Hall is still in the process. The architects are working on it. 275 for museum repairs. We have about another month and a half and that project will be completed. This past year, Representative Vincent gave us 670,000. That money is sitting in the bank waiting for construction. So we have that set aside also. We also got TPF fundings for chip sealing and micro sealing roads. We have 3 roads this summer, which will be Joe Welsh, Turkey Canyon, and Riverview, I believe. It depends on, we're gonna measure the inflation to see which roads we can still do. Been very frustrating. We apply for these monies and by the time they award them, everything's went up and then we don't have enough money, so we'll make it work what they gave us. Reservoir Drive, we have the money for that. It is going out to the contractors for pricing next month. That's what I have on the grants currently. Maintenance department completed 14 work orders last month, along with painting of some of the courts and other areas, preparing heaters. The garage completed 8 work orders. He does a lot of welding for us, so we've built cages, we've done a bunch of repairs. We have a water truck that we got that the whole bottom floor is falling out of it. So he's actually putting new metal on the inside. We're rehabbing the truck. Parks department is just parks. They kind of just keep everything going, keep the bathrooms clean and what they can do this time of year. The streets, they bladed the base course roads last month. Bladed North Lane, added base course, installed and cleaned our yard. They patched potholes with what we could. Removed asphalt from a north central sinkhole and investigated that. Water and wastewater, they had 20 work orders, 7 locates, 3 emergency locates. And this won't be on, I'm just gonna tell you now, we just had a VFD pump be put in at Riverside Well, which is gonna be tremendously helpful for us because we're only allowed so much water. We can only pump so much water from the ground. And it's like 363 gallons per minute. The spring, I've seen it down to 160. We have this beautiful new well that was designed 15 years ago and pumps 2,000 gallons a minute, but I can't pump that with that restriction. So we've tamed that well down where it will pump from 100 to 400 to cover us in case something ever happens here. We have plenty of water. That being said, last year council gave me some money to buy a generator. By the time we tried to buy a generator, they've doubled in cost. So this year I will come back to y'all for money for a generator because if we don't have a generator and the power goes out, you're not gonna have water. If on this new well, the old, we have a generator there, but you know, they're hardwired in, they're transfer switches, you can't just move them.
Where's the new one at?
Down on Riverside, it's by the park. It's been there, they did it about 10, 12 years ago, they drilled it. We're finally getting more equipping to it and getting it.
Right there on the corner.
It's a great well, I mean, it's 2,000 gallons a minute, but what do you do with that when the state says you can't pump it? So we got that where it's pumping, so that's a good thing. Last month for your water rights, we produced 8.8 million gallons. We sold 7.27 million gallons. Shows an 18% loss, which is 1.5 million, but that ain't really a loss. You got over 3 million gallons of storage between all the tanks. So we're doing pretty good. We're all right. We're not hurting right now. You know, summer comes, we might be stressed a little bit, but that's just because of pumping conditions and the rights the state makes us abide by. Any other questions?
I have a question. So in the summer, when we go on to water restrictions, is that related to tourism at all?
Yes and no. The water right restrictions are based off of what the spring produces. And so as that spring produces less and less water and people are using more, I've got it set at like, I don't say it's 10, 30, and 60% reductions to try to go into restrictions to help us. But I'll be honest with you, I don't know that it helps one bit because we've been at stage 4 for 10 years. No,
Yeah, I was
6
just
years.
saying.
Ain't nothing changed, you know, we make it work and we try to do our best to keep people from watering during the middle of the day or filling their swimming pools. But it's all based off the spring because that's our main source and that's where the water rights are. Those water rights have to be exhausted to a certain point where the spring produces a certain point before we can use those at the other wells.
If the person wanted to know the cost of water, and maybe not per gallon, but a cost of water, who would it call?
I can tell you that honestly. I can tell you it's way less than 0.0001. But it'll take a while to figure it out.
I found it online for the village, but I didn't find it for us. Would it be comparable? The village?
No, the villages is way more expensive.
Oh, good.
They're treating water. They're taking river water and lake water and trying to clean it up. You know, with all the E. coli and everything else in there. We don't, all of our water comes out of a crack in the side of this mountain. And that's why it's hard, but it's natural. There's nothing in it. It's really super clean. It's just hard as can be.
One time Councilor Miller suggested that we bottle that water and sell it as water down spring water.
It's good water. It's hard. And the only way to fix that is soften it. And we couldn't spend $10 million to build a softening plant.
Could we
The cost of water would be like buying it from the store at $1 a gallon.
If we advertise it as high in minerals and make them charge more, would that one?
Maybe.
It is spring water.
Yeah, it is. It really is.
Thank you.
All right, thank you.
Thank you, Joey. Jeanette, you want to get yours over? So you won't have to sit there and read it?
Hi, everyone, Mayor, members of council. For the month of January, I had 1 building permit, 1 demolition permit for the rest of that motel, 1 conditional use case, 1 replat for 26482 Highway 70, and 1 mobile home permit and 1 animal license. Any questions?
Yes,
Thank you, Mayor.
Counselor.
I've had a couple of our citizens come to me recently, and there's one here in the room, that their address is not correct for where they live.
Yes.
And I looked it up in our ordinances, and it seems like you're the person.
Yes.
Restrictions. And how would a citizen go about getting their address corrected?
I think, I don't know, maybe 10 years ago, the 911 changed the addresses for everyone to comply with them. And they can come with me and I'll give them a letter saying that because of 911, we changed a lot of addresses and they can take that to the bank or anything. So they can change that.
Okay, so a citizen comes to planning and zoning.
Yes.
And asks you for it.
For a letter. And then they also, I can write a letter for the county if they need one for the county as well.
Okay, so if they were responding in a 911 situation, are you going to give the citizen, this is your real address, that 911 address,
Yes,
regardless of what they think they have?
yes.
Okay, and
The
then
change.
that would be a good time to put it on the building or put it on the road or put it out for.
Yes.
emergency reasons?
Yes, it's for 911.
Jen.
Counselor, to help you a little bit, as I'm recalling a long time ago, with the 911, it was explained to residents, hey, would help you if an ambulance, and you're needing one in a hurry, needs to have an exact address. Steve Dunnigan was in charge of doing all that. It was quite a job to get all of that changed over. And he ran into more than you might think. I'm not changing my address. I've had this forever and I'm not gonna change it. So some of it just didn't get changed as far as the physical address, which, that's dangerous. If you got somebody that's got a heart attack or something, an emergency and they go to the wrong address. So that's some of the history behind it.
Thank you. And I do have a spreadsheet from old addresses to the new addresses. Okay, good.
Thank you, Jeanette. DC,
All right, Mayor, member of the council, January was kind of a slow month for us, which is a good and a bad thing, but we had 12 total arrests for that whole month. Becker was the top producer and the rest was 5 of the 12. And the citations for the month ended up totaling 78 for the month. Again, Becker was the top producer in that one with 54 of the 78. And that's pretty much it. I stand for any questions.
questions, counselors? Okay, thank you, DC.
Yes.
Chief, Fire Chief, would you give us a report on your department?
Counselor. I didn't have time to generate numbers on everything, but so far this last month, just doing fire inspections, business licenses, and then running calls. But like I said, I didn't have time to generate the numbers to give to you how many calls. So other than that, that's all it's been for this last month.
Counselors? Okay, thank you, Chief. Do we have Mary here maybe on?
Yes, she's on the phone.
Mary, can you hear us? Mary, can you hear us?
Yes, sir, I can.
Okay, would you give us a report on your department, please?
Yes. Yes, sir. So, good afternoon, members of council, Mr. Mayor. Before you is January's financials. Have you guys had time to review them?
Basically.
The answer was basically,
Okay. After reviewing the financials, are there any questions you have for me regarding these financials?
there are none, Mary.
Okay. I stand for questions. If there are none, then I have nothing further.
Okay, thank you.
Yes, sir.
That takes us to the next item is,
Before we go on, is there gonna be a court report, or the court be reporting? A court, normally the court.
I don't have that listed. I don't know. We can do that now if there is a report from the judicial department.
Well, the fire department wasn't on there either, so go ahead. If it's okay with you, Mayor.
I guess so, since you've already okayed it.
Mayor, members of council, for January, the court issued 6 new warrants. We reissued 13 new warrants because we're going through our warrant book. We had 4 driver's license suspended, 8 cleared. We had 77 people on our docket. We heard 47 cases, 17 of those were trials. We saw 5 people in jail. We had 1 wedding. We had one dismissal for an officer no-show and one dismissal for paperwork being turned in incorrectly. Any questions?
Thank you, Bob. Yeah, under monthly reports, that wouldn't have to be on the agenda. That monthly reports are for every department. And so if we want to put that in there, we can. All right, this takes us to the public hearing. John, you don't have to double check me on this. We don't do these but once a year.
Just go ahead
We need
and
the
read-
agenda.
go ahead and read it, Mr. Mayor, and I'll take it.
The agenda item. And you know, I brought, do you have that?
I do.
Would you read that, please?
Public hearing, Sarah Sorensen on behalf of herself, Will Sorensen, Charlie Sorensen, and Mike Sorensen, appeal of planning commission approval of P and Z case 2023-11, approving the conditional use to allow for recreational park at the property located in a C2 zone district. So it's the first one of these we've had in quite some time, and certainly with this new council. So I thought maybe I might give you some ground rules of where we are. Appeals are handled in section 155.021 of the land usage code of the city of Ritos Downs. So a person has a right to appeal a decision that was made in the planning commission, this commission. And then a person who has agreed with this decision has a right to appeal that on to district court. For that reason, I will be swearing in all witnesses today. Because today's testimony has to be taken verbatim because it's a court record. So with that, the way that this works, the way that we'll have it is that the appellant can present their case first. Okay. I will ask Jeanette to introduce the subject on behalf of the city, and then the appellant will have the opportunity to state their reasons for their appeal. And the appellee, the person who was granted the conditional use permit, will then have the opportunity to state the reasons for not granting the appeal. Each party will have the right to cross-examine witnesses of the other party, but I want you to understand, counsel, that I'm not going to follow specifically the rules of evidence. If you become argumentative with a witness, I'll ask that you not be argumentative. I'll ask that you try and hold down leading questions to a minimum, but in order to move the matter along so that we're not here at 10 o'clock tonight, I'd ask that we move the matter along expeditiously, but I know it's an important issue to the parties that are involved in it and deserves a full hearing. At the close of that, I will present the city's case of why the planning and zoning decided the way that they did, and under what theory of law they found that there was conditional use should be granted. And after all that is heard, the public will have an opportunity at that point in time, those who haven't been witnesses prior to, if the public has any reason that they want to state one way or the other what they believe before the council takes it under consideration, they may do so. After that point in time, it turns into a council matter, and the council can then discuss whether or not to uphold the appeal or to deny the appeal. Questions?
Yes. Does that mean we're literally voting on that today?
Mhm.
Oh, wow.
So I didn't
Yes.
understand that either. I thought it was
You may
just,
delay your decision for a period of time. But it is a matter that's being appealed and to be voted on at the time of the appeal, or if you want to put it off through the provision for putting it off for, what is it, 15 days?
And as I stated a while ago, when you, Rosette, you'll be getting the information, correct, John? From
The city
both
council will
sides
hear the appeal
today.
and render a decision within 45 days. So.
we could put it off then. So I haven't had a chance to go look at it or anything yet.
Okay, so,
But the witnesses and the attorneys are not required to come back. You will just simply be working on what you. written down, and you're permitted to take notes on it.
Okay, thank you.
Okay, so I guess the next move then is to ask for a motion to postpone
No,
this item? No?
no. What we'll do is we'll go ahead and have this hearing today, and then the council, if it doesn't want to make a decision
Okay.
today, may postpone that decision.
Okay, yeah, well, that makes sense. Okay.
Hi, Mayor, members of council again.
This will be the city's, position. And,
Basically, she's just gonna present what happened at the planning and zoning meeting. And we have minutes of that planning and zoning meeting, which we'll be happy to hand out where the decision was made, but the decision itself is in your notebook.
So, Mr. Edgar Ontiveros came to apply for a conditional use to allow for recreational vehicle park at the property located at 26557 Highway 70. There were some issues with how the ordinance was written, but how the planning and zoning commission took it and interpreted it themselves. They decided to grant the conditional use, required because it's in the C2 commercial property. And I also have, Mr. Luther Light here, the chairman of the planning and zoning commission. So he can explain that a little bit better than I can.
Yeah, now.
Yes, please.
Yes, I'll go on.
During the, I guess the neighbor's challenge to this is that the property in question has an easement running through it, an egress easement. The property is down by the river, and there's a 30-foot wide egress and utility easement running through another piece of property up to Highway 70. The people whose property that runs through, I guess, are opposed to using the piece of property down to the river as a RV park. Their case was that our ordinance says specifically that recreational vehicle parks shall abut and have access from major arterial streets and shall be a minimum of 2 acres. So this meets, the property down by the river meets the minimum of 2 acres. Their argument was that it doesn't technically abut Highway 70. The Planning and Zoning Commission, along with Mr. Underwood, read abut and have access as they have that easement out to the highway, and it's a 30-foot wide easement, which is basically the width of what our streets, all of our streets except Highway 70 have as a right of way. So it's certainly big enough for 2 RVs to pass, you know, side by side, going in each direction on the property or on the easement. I guess in the meeting, the Planning and Zoning Commission decided that the intent of this access requirement and general requirements is that we don't want a 2-acre RV park to exit out into a small residential street. Like you wouldn't want a 2-acre RV park to dump out onto River Lane and then have all the RVs have to go down River Lane and then up Parker Road to get to Highway 70. The intent is that they have essentially a driveway to a major arterial. Our major arterial is Highway 70, and they do have a driveway to it. So we interpreted abut and have access as being their egress easement across this other piece of land. We did offer, the neighbors were also concerned about having children on this, you know, maybe being in danger on this easement, and we offered to have as a condition to have, you know, put up a fence along both sides of the easement, so to keep people from running across in front of RVs. And I think they declined that. I
Never heard back.
never heard back. Okay, so we offered that as a minimum, and we also set a 5-mile-per-hour speed limit as a condition of granting this conditional use. It's probably one of the highest and best uses of this piece of property, and I think it would bring in, you know, gross receipts tax for the city and the people who bought it intended into an RV park from the time that they bought it. So from the Planning and Zoning Commission's point of view, seems like a good use for this piece of property. And we certainly seem to have a need for RV parks in the area. So that's any questions?
So the lawyers are reading it one way and you're reading it another?
Some of the lawyers are reading it one way and some of the lawyers are reading it another. And the Planning and Zoning Commission is reading it, I guess, in the way that I think it was probably written in for the way we design our RV parks in this town. I mean, there are other RV parks that have the same amount of access onto Highway 70 across other pieces of property. So, and we tend to not have RV parks that dump out into small streets.
Councilor Parker, did you have something?
Yes, so what you're saying is that property down there by law should have had a piece of their land that went all the way up.
No, not necessarily. I mean, like, when they subdivided it, they, because you can't have a landlocked piece of land. So when they subdivided it a few years ago, they specifically asked or had the surveyor draw in this easement. And that provides access to the piece of land. It doesn't really have to be a property. I mean, I live on a road on the north side of the river, and the city maintains the road, but it's on my property. The city has an easement for Parker Road through my property. It's the way many roads are done. So it's not, I don't think there was an oversight not having a piece of property run up to the highway. The way this has always been taken care of is usually we put the easement along an existing road, which is, I believe, what they did. They just ran the center line and then offset it 50 feet on each side. And, you know, it can be improved and would probably have to be improved, but there's no oversight on the part of the surveyors or the previous owners to maintain an actual physical piece of property. Having an easement is very common for this type of situation.
So the easement that I looked at on the map, Luther stipulated that it was for utilities underground.
Utilities and egress.
I didn't see the word egress on there.
It's on the plot, the main plot that we were given. It said utilities and egress. The driveway, that's. There. A utility easement is typically, unless it's a very big utility easement, like for an overhead power line, a large overhead power line, those are usually only 10 or 15 feet. So 30 feet is usually the standard for a road.
Councilor Miller?
I just feel like, that's what's in that area quite a bit is RV parks. And, I think it would be a great thing for people. There's not enough houses for people. A lot of people can't get workers because they don't have anywhere to live. And you see how these other parks fill up in the summer, not so much in the winter. But it is a good business, it sounds like. Yeah.
That's kind of beyond the scope of planning and zoning. I mean, you asked my personal opinion, would I like them to put in a bunch of affordable homes? Absolutely. Would they be profitable? Probably not. So I understand why they're doing RVs. You know, planning and zoning, they just said, we want to do this. It's conditional use. We heard it. This is what was our decision. Why?
Well, I feel like it would be a great business for Ruidoso Downs because we don't have that many, you know, places for people to live. We get people here that want to come and work, but they can't find a house a lot of times or can't. So
I will say that it states in our ordinance that the only place in the city of Ruidoso Downs where you can currently live in an RV is in an RV park.
Yes.
So you want people to live in, like, be able to live in RV parks if they are, you know,
they're small homes.
affordable, you could like live in an RV park.
Yeah.
So in that respect, it does provide, I guess,
But
affordable housing.
I haven't had a chance to go out and look at it. Seems like every time I want to, something comes up, but I think
Councilor
I want to
Lacewell?
hear everybody. I want to hear what all the neighbors say. In other words.
Councilor Lacewell?
So I looked at this, I printed it out. I colored it. That RV park is a great idea. It looks a little landlocked. Did I understand you to say that the easement is 15 feet on the Sorensen property and? 15
No,
feet-
it's all on one piece of property. I'm saying it's 15 feet. The way surveyors typically lay these out is they just run the center line of the road
Yeah,
and then offset that center line 15 feet on each side of the center line. So they put the easement on top of an existing road rather than putting a road inside of an easement.
I see. And I did see that it said that the driveway easement, but to me, a driveway easement is to get to home. Whereas a commercial easement or something that was more designed for a whole lot of traffic. I'm not Solomon here, but it seems like the easiest way to fix this is to make a new easement that goes across the Lewicki property and straight up there without getting into the Sorensen property. Is that a possibility?
I have no idea. I don't know any of the neighbors. I haven't the foggiest idea. I mean, they could, if you could find somebody else who would give them access and would allow them to set up an easement, that would certainly be allowed. They would have to replat it.
Okay, and I know the Sorensens are up on the screen there. Will the Lewicki's be given an opportunity to speak as well?
I haven't the foggiest idea.
Oh, you're not in charge of this meeting?
I am not in charge
Well,
of.
thank you for your information.
I would like to state, because I think this might be an appropriate time. Counselors, we are really fortunate to have the P and Z committee members that we do, especially Luther Light. He's been there a long time. I attended that meeting that concerning the topic that we're talking about. City attorney is always there. That was an interesting meeting. But this chairperson is very intelligent. And we need that type of decisions there because it's a very touchy situation. He does a tremendous job. Actually, I think we should double his salary.
Which I'm zero is, I agree.
What is 2 times nothing anyway?
It's always zero.
But he's been doing this for years and not only smart, but he has so much experience now behind him. At one time, politically, I can recall, he may not even know this, but I wasn't in favor of him too much. But how things can change. Thank you for your service to this city. You really have hung in there.
You're right. I was not aware that you were political. I appreciate the sentiment, sir.
Okay,
You need me for anything else, Mr. Goodwood?
No, sir. So thank you, Commander.
You're welcome.
Luther also serves on the local school board. He's a man of many,
yes.
very talents.
I get paid nothing for that, too.
He has a night job. So since we kind of jumped ahead there with the city's presentation, let me go ahead and say some things that you need as a basic knowledge as we've gone through this. The first thing is the property is zoned C2. C2 is the commercial zoning, okay? That property was zoned C2 in 2004 when the city acquired that property. So the document that I just handed out to you will show you that the appellant got a deed, a special limited warranty deed to that property in 2014. So that special limited warranty deed contained no warrants as to what was being given as far as that it wasn't subject to restricted covenants.
Hold it just a second, John. We need to have it quiet. The council could miss something that might be really important when it comes time for them to
They
vote.
received it by special limited warranty deed. That means there was no covenants with this deed. There were no guarantees with this deed. And it was subject to the zoning that was on the property at that time. So they acquired it 10 years after it became C2 zoning. So I think that's important that the property is zoned for conditional use for RV park. And if you've looked at the easements that are record, those easements are dated prior to the date that they acquired this property. So any of you who have bought real property know that whenever you acquire real property subject to all easements and reservations of record. So that property was acquired with easements of record. As to whether or not that would be something that would be used as a driveway to a residential home, it would be, but for the fact that the property was zoned C2, which would mean that the driveway, which is 30 feet wide, which is almost as wide as a city street, is meant to be used for access to a commercial piece of property, which there cannot be any doubt. The last thing that I want to let you know is that the easement of use, the person who has the right to use that easement is called the dominant easement, it's a dominant estate, okay? The person on whose property that easement exists is the servient easement. So whenever the wiki or the folks that bought track 2, whoever buys that piece of property, that easement, although it's a non-possessory easement, it's a right. That right to that easement, the right to use that easement for the purposes of access and ingress into a commercial piece of property transfers with that easement. And that's according to New Mexico Supreme Court. That easement is pertinent to that piece of property. And so those are in the legal way, what Luther was saying in the layman's way of why the Planning and Zoning Committee feels that that piece of property does in fact abut an arterial road, which would be US 70. So with that, does the appellant want to talk about do you want to say something?
Yeah.
Go ahead, Jim.
And I do know, we just talked about it, the property was annexed to the city in 2004. So when they were annexed to the city, they were annexed as commercial zones. So the zone was never changed when we acquired it through the annex.
All 3 properties.
Not just those 3 properties, it was all of Fria. I provided you with a little map of the whole map that was annexed back in 2004.
But the answer to your question is yes, all the tracks involved in that plan.
Yes, but it was not just them.
You can't just spot zone one.
Yeah.
The whole thing, all that was acquired on that
Yes.
side of the property.
So all that land on that side of the highway is commercial.
Is it on both sides?
Yes.
Yes, it's both sides of
I
it.
think on the other side of the highway, I think it's that part is in the county.
Can't quit Squanco.
No. I think it's on both sides because I've got friends that own property.
Oh.
Now they're in the city.
Okay, but I did provide you with a copy of the commercial of the zoning that it is right now and how it was when they got annexed as well. All I wanted to say.
Okay, thank you, Jeanette.
Is the appellant present?
Good afternoon, Mayor and council members. My name is Melissa Martin, and I am an attorney representing the Sorensen family.
Okay, we can hear you. Thank you.
Do you have some
Okay.
witnesses you wish to call?
You know, I had some things to go over with the council, if I may. I don't necessarily have a line of witnesses, but I did have a statement to make.
That's fine.
Okay. Well, council members, as I said, I'm an attorney. I'm barred in the state of New Mexico. I practice with Scott Hulse Law Firm with offices in Las Cruces and El Paso. And I'm representing the Sorensens in this matter. And as your zoning commissioner correctly stated, this issue really boils down to the word usage in the city of Ruidoso Downs ordinances that state that a recreational vehicle park shall abut and have access from major arterial streets. And we see this really having 2 issues, the first of which the commissioner as well as the city attorney did touch on, which is the question of abutting a major arterial roadway. Now the Code of Ordinances does not define the term abut, and in such a case, the Code of Ordinances does state that will default to the customary definition of the word. So Merriam-Webster's defines abut as to border on or to touch on an edge. Cambridge Dictionary is next to or touches on one side. And Britannica Dictionary says to touch along an edge. There's this, it seems that the zoning commission has determined that because there is an easement present, that means that the property also abuts a major arterial roadway. Now that's contradicted by the plain language of your city ordinances. And I'll go over that first. If this ordinance were just meant to say if there's some access to a major arterial roadway, there's absolutely no need to include the term abut and have access to. Words have meaning, especially when it comes to city ordinances. And you can't simply ignore the term abuts and simply say because there's access that you have some border of your property abutting the major arterial roadway. Now there's an argument, and this is my second point, that's been presented today, that because there is an easement present, that automatically qualifies the property as abutting a major arterial roadway. If you follow that line of reasoning, commissioners, and I would ask you to consider the fact that there are public easements, every street, public rights of way throughout the city of Ruidoso. And I would argue that any 2-acre piece of commercial properties, zone C2, could find an argument if you interpret this abut and have access to in the way that the city attorney and the zoning commission requests. Any 2-acre C2 property can say, well, I do abut and have access to a major arterial roadway because I have a public access easement to it. I would argue that 95% of the C2 land in Ruidoso could use that argument. And frankly, it seems that there's a desire to interpret the statute in a way to allow what's best for business as the city sees it. But that doesn't give anyone the right to simply ignore the terms of the city ordinances that say abut and have access to. If it's true, what your zoning commissioner stated, that the intent of this language was really to keep commercial recreational parks away from residential, multiple residential neighborhoods, that could be written into your city ordinances, but we have to interpret the ordinances as they're written. That carve out is not in there. And to treat one property owner differently based on, what you think the intent of the statute was really is not the purpose, I would argue, of city ordinances. So that's the question of abuts. And the second issue, which I think the zoning commissioner and the city attorney didn't touch upon, but that was discussed at the zoning hearing, that is really quintessential to this discussion, and which I've elaborated on in the appeal that you all maybe have reviewed or will review after this hearing, is that every easement is not created equal. Just because there's an easement across the Sorensen property to this landlocked parcel and it's zone C2, that does not give the landlocked party ability to use that easement however he sees fit. Under New Mexico law, an easement should be construed according to its express and specific terms. And when express terms of an easement are ambiguous, as they are in this case, the intent of the parties should be determined from the language of the granting instrument in conjunction with surrounding circumstances. Now, it's been almost 20 years since this easement was put into place. And easement scope, the scope of use is not determined by zoning in the state of New Mexico. Again, it's determined by the prior use and surrounding circumstances. For 20 years, this easement has been exactly what the zoning commissioner stated in the introduction to this discussion, which is that this was a landlocked parcel. It was subdivided, and because it was landlocked, an easement was granted to permit the property owner access to and from that landlocked parcel. That does not mean that that landlocked parcel can then use that easement for any use it sees fit. It is a very different circumstance to allow a commercial property owner ingress and egress to their estate, and then to open it up to unilaterally change the scope to ingress and egress by thousands of recreational vehicles per year. That is simply a change in the scope of the use of the easement. New Mexico law prohibits that. New Mexico states that easements should be construed very narrowly, and you cannot just unilaterally expand the scope. And so I would encourage you, please, to review the appeal that we submitted to you in writing. This will state the cases from the New Mexico Supreme Court supporting this argument. But this property simply does not abut a major arterial roadway. A right to cross the Sorensen property does not mean that they have any title or interest to the Sorensen property. It is not the Excalibur Oils property that abuts the major arterial roadway. It is the Sorensen property. And as well, the scope of the easement simply does not permit the use by thousands of recreational vehicles per year across a residential piece of property. So that's my statement, and I'm happy to take any questions if you have them.
John, is that appropriate this time?
Sure.
Counselors, questions?
Yes,
Counselor.
Terry Proctor's counsel. Ma'am, do you have the New Mexico state ordinance or the law that stipulates they can't use that as they proceed to use it for the purpose you just explained?
Was that a question for me, counsel?
Yes.
You know what, I do, and I'm happy to send it to you again. I sent it to Jeanette. It's part of the appellant's appeal petition.
Mayor,
Yes, Counselor.
one question for Ms. Martin. Ms. Martin, this is Jody Lacebaugh, I'm a city councilor. I noticed that the property on the west side of Sorensen is the Heritage Operating LLC. And then on the other side is the original Wiki property. And that luckily for the Sorensen family, they purchased that little peninsula that hangs down for access to their own property.
Right.
And it seems it could have been just as easy. I don't know who owned, I guess the Louis family owned that before. It seems to me that a more direct access that goes straight from the park and down to the highway would be a more logical way to do this than to expect the Sorensens to allow, like you said, hundreds of RVs in and out every day. I know the RV parks I've been to, they don't just go there and stay. They go in and out, they go to the track, they go to the grocery store, they go in and go out. And I don't know, it seems like a lot to ask the Sorensens to absorb. They have all of that.
Yes,
And
Councilmember, I'm sorry, go ahead.
That wasn't even a question. That was a statement.
Statement. But yes, Councilmember, I would agree with you. You know, but staying true to my interpretation of the city ordinances, I would argue that even if the access easement was relocated to the Lewicki property, again, an easement does not give you the claim to abut a major arterial road. However, I did make that point in my presentation at the zoning commission. I know that the Lewickis, for whatever reason, are very adamant that they want this RV park to go in, despite, to my knowledge, not being associated with the party that purchased the landlocked parcel we're discussing. However, I do agree that if the Lewickis are so eager to have it be placed there, that, you know, short of interpreting the statute as, you know, or the city ordinance as I believe it should be, the second best option would be that the Lewickis grant their own easement across their own property, rather than, as you said, as I said, having hundreds of campers, RVs, whatever, a day crossing through my client's residential property. I would agree with that statement.
Any other questions, councilors?
I want to clarify one thing. I think Counselor Proctor asked the attorney, Ms. Martin, if she could provide, did you state that you have a state statute stating that a easement, if it is unlimited in its terms, leading to C2 property, that would be an ambiguous easement? Do you have a state statute to that effect?
I'm not sure. I apologize if I stated it differently. I wouldn't state that I provided you all a statute that specific. What I provided you all is rather case law on this matter, stating that when an easement's use is not specifically set out, that yes, that ambiguous use would be, sorry, if the scope of an easement is ambiguous based on the document that grants the easement, then yes, the surrounding use is what would interpret the scope of that easement. And yes, you should have case law providing for that language in the appeal that I sent you.
So if the surrounding use is commercial, that's what should define the scope of that easement, is it not?
No, it would be surrounding circumstances. And again, I would argue that, nowhere in the case law have I seen that, well, it's zone C2, so anything flies. I mean, that would essentially be some sort of a public right of way. But no, and to the extent you might like me to provide a more pointed case law, I'm happy to do so. But no, I've seen nothing in the case law in my time practicing in New Mexico that states just because something is zoned commercial, therefore it's free game. It goes back to the surrounding circumstances, the past use. If it's been used for 20 years as an old dirt road to haul cattle down, it's not suddenly going to be a commercial highway, and that's not a problem. I mean, that's what I mean by the prior surrounding circumstances.
So Ms. Martin, there's been no testimony that there's going to be hundreds of RVs daily crossing this piece of this easement, is there?
Well, I don't know that we've had anyone testify as to how
Correct.
many recreational vehicles a day will pass, but I grew up camping as a kid. I'm sure y'all did too. But my understanding is there has been testimony that I believe there will be 42 camping spots available at any given time, 42 RV spots. So, you interpret that as you will, but I would say it would equal thousands of in and out per year, as I stated.
And so let me ask you one other question. You're saying that the easement would be ambiguous because it had no limiting term. If the easement, if you don't deny that your people acquired property in 2014.
No, I don't deny that.
So if they acquired that property by special warranty deed, which means they got no special warranty covenants with that deed, and if that property was zoned C2 at that time, and if that property had that easement across it leading to a C2 piece of property, and if that easement has no limited language in, this easement may be used for personal use only, that means that that easement is not ambiguous whatsoever, but rather leading to a C2 piece of land that was C2 when your client acquired it.
Well, again, I don't think that you can, again, it goes back to the surrounding circumstances, the prior use for the past 20 years since the easement was established. And for the past 20 years, I know that the appellees have stated that at that time, this wasn't intended to be used as an RV park way back when they subdivided the land. So again, the ambiguity is resolved by determining how has this easement been utilized for the past 20 years. And if the city council now is stating it can be utilized for a completely different purpose, be it commercial, residential, industrial, you still have to look at the surrounding circumstances. It doesn't, being zoned a certain way certainly does not give you, I'll give you an analogous circumstance. A residential, a private easement in residential land, utilizing a residential easement just for any way you see fit is just simply inadequate. Again, the easement should be used for the purpose in which it was granted. And if those terms are ambiguous, it goes back to the prior use. And the prior use for the past 20 years has been far from hauling RVs, campers, whatnot, in and out of that property. It's completely different.
May I address Ms. Martin again?
Yes.
Ms. Martin, this is Jody Whistle again. So I think as a council, we're excited that there would be an RV park back there. I don't know whether or not the Swansons are unhappy about the RV park or just about the easement, but if the Lewicki family is willing to move the easement over to their own property, would that make your clients happy?
Council, I would have to, I don't want to speak too much for the Sorensen family. I certainly I am very certain that would be far superior to placing this easement to an RV park right across their property. I am certain that is the case. I would imagine that relocating that easement to the Lewicki property would be a more appropriate resolution to this matter in the Sorensens' eyes. I can't say they'd be jumping up and down about it, but and as I said, I think that the ordinance still speaks for itself, that this really isn't an appropriate use of the term abut. But it would certainly be a better resolution than we've reached at this point.
But let me remind the council that that's not the issue before the council today. This is the appeal of the use of the easement leading to the C2 property. Whether or not there can be another resolution is not the issue before you.
So this is all about an easement and not about an RV park.
No, this is about an easement that exists to an RV park, to a C2 piece of property. This is an appeal from a conditional use application in planning and zoning for the placement of an RV park in a C2 piece of property.
Mayor, I have one
Yes,
thing to
Council.
ask. I was on the council when this was annexed in this property. And I think whoever owned it at that time should have probably come to the public hearing if they didn't like it being C2. Because it was annexed in by the city of Red Osa Township in 2004. And that was because we were giving them services already, police service. And we bought the water from Agua Fria, the well. And that's why we annexed in all this property. And I think that was probably the time they should have. That if they did not want it to be C2, they wanted agriculture, whatever.
Yes.
Yes, ma'am.
In 2004, the Sorensen didn't own the property. Did Lewicki own the property in 2004? So,
Can we wait till we get to that part?
Yeah, okay. That was just the thought that came to me.
Council,
they
and
didn't want
that's
it
correct.
C2.
The Sorensens did not own the property at that time. Otherwise, I'm sure they would have, been mindful as they have been in this situation. But also the easement itself also hadn't been created. So even if our client had owned it at that time, they likely wouldn't have had an objection. But for this 30-foot easement now crossing their land and bringing, RVs into their property.
I understand.
Happily.
No.
Does the. No. No.
not yet.
No.
So you're asking the Lewickis?
I'm asking for the applicant for that got the conditional use.
I thought you said something different.
Sorry.
Hi, I'm Alexandra Bobbitt. I will be representing Edgar Ontiveros today. Hi, my name's Edgar Ontiveros.
And John basically took a majority of my job from me. I had all this stuff ready and then he started up. So I unfortunately will be reiterating some of the things that he has stated. However, one of the key points and one of the key issues that we have had is the fact that when the Sorensens purchased the property in 2014, it was very clearly, and I think we can all agree, is that it was very clearly zone C2 at that time. And so there was a very, and if they were not aware that their property was zone C2, then that was a responsibility that they had as property owners to know that there was the ability, there was the possibility that there was going to end up being some form of commercial access. And so to kind of now all of a sudden go back into this thing about how the easement is being used for something different and you know, and this changes everything. It doesn't really, because there has always been the ability for either themselves or for whoever was going to purchase the property around them for there to be some sort of business that would go in. Now, if anything, I would actually say that having an RV park go into that area would almost be more beneficial than having some type of property where, or some type of business that goes in that has constant in and out access. Like for instance, I think, you know, for, let's take Harvey Feed Store, right? So that one is straight off of the highway. That one has customers that come in and out, are continuously coming, going, coming, leaving, so on and so forth. That is a very different type of traffic than you would have with an RV park. An RV park, while yes, there can be RVs moving in and out, but typically for the most part, people are going in. There's the river back there. The idea is that this is going to kind of be an oasis for travelers. Should people decide to live back there, that's going to be the same as if you are in a residential area, as if you are coming and going without this constant access of like a turnaround that you would have again at somewhere like Harvey's Feed Store or the Lots of Stuff place. And so if anything, the idea that this is changing the scope of an easement that exists, we can kind of have it go both ways. So for instance, if we're looking at the RV park and if we're going to argue that the area has this residential nature to it, then if anything, an RV park is going to be one of the things that is going to lend to that residential nature. It's going to be something that isn't going to have this constant continuous flow from whatever hours the place is open, but it's going to be more of a leisurely pace. However, again, the easement doesn't actually have any specifications. It doesn't have any limitations in terms of it can't be specified commercial traffic or it can't be large vehicles. It doesn't have any of that. And actually, if we look, and this has been supplied in your documents, and when you have the chance, I'm just going to be asking that you really review the Lewicki Land Division and Grant easements. That one looks like this. And this is the one where it basically kind of sets up where our easement is. And it does show this really long road here, and then it shows this kind of short section here. And this short section is really where we're going to be addressing, because then at that point, the easement does come all the way up and come into here. So the idea that it's really taking over their property isn't very true, because this easement over here, that's probably your biggest, longest easement, is the one that's not going to be in use. It's going to be this shorter section in here that then takes you straight onto my client's property. The next one that I want to be asking that you really review is going to be a replat of Lewicki Land Division Tract 2. And this one actually has the definitions. It says easement. And so where it says easement B, it's pretty clear in the fact that it states, and it's very, very small writing, and I almost had to get a magnifying glass to stare at it. But it states a 30-foot wide easement for access and utilities. So for access and utilities. It is not specifying that it is utility only. It's not specifying that we're changing anything in the easement. We're still maintaining the access part of the access and utilities. And then, and so then going to, you know, the case law and all that was laid out. So one of the things is that when I was reviewing this case law was, yes, when it comes to the change, like there was one of the cases that it was taking, I believe it was taking the case from being a utility type easement and a water type easement, a drainage type easement, and then someone was unilaterally changing that easement to become more than just water drainage. But here, we don't have that. We still have the same access. We still have the same definition of access. Access, of course, being coming, going, ingress, egress. So the scope of this easement is not being changed at all. It's still being maintained. And so I really come back to the fact that when this property was purchased, it was purchased with this easement already there. And it was purchased as a C2. And so the Sorensens knew exactly what they were getting into. They knew exactly what type of purposes could go back there. They knew that there was these easements that ran across their property. So none of this is new. No one's trying to change anything. No one is trying to reinvent anything that has been here. We're not asking for anything additional. It's simply that they have asked to put in an RV, and we do truly believe that it is not necessarily the easement that's an issue here. We do truly believe that the Sorensens do have concerns over the fact that it's an RV park, and what does that mean, and what does that sound like, so on and so forth. And so I just want to make sure that we have that clear when it comes to this idea that my client is unilaterally changing the scope of this easement, that is not what is happening here. When he bought the property, with the easement, and that it was all C2. It was an idea that was going to be C2. And so therefore, he is just following along with what has been recorded, what has been deeded. And so he has been acting accordingly, and he has not been asking or wishing to change the scope of any of that, or to make any large unilateral changes. And that is that he's continuing to follow the easement as recorded, where it states access and utilities. And so then that brings us to the idea of, does this constitute abutment? And there was the idea given that if you are up against a public roadway that then goes to the highway, then that is, that then everyone can kind of think that they abut to a highway. And that's not what we're saying here, because the large difference in this is that this easement is not a road or any type of roadway, anything that is actually, in my understanding, is that that's actually maintained by the city of Great Oso Downs. This is an easement that is actually made part of Mr. Ontiveros' property. And what that means is that he is, as being the dominant servient in this easement, is that it does create the point where he is the one that is maintaining the roadway. It is his roadway. It has been given to him. So in being the dominant, that is still his land that takes you to the highway. And so since it is his land that takes you to the highway, as it's been granted to him in the grant of easement that we've supplied for you, that he does in fact abut up to a highway. This isn't something where, you come out of here and you come to the public road and then you come down. That would not be abutment, right? So that would not be something that he would then be able to claim. But by actually having the easement be part of his property, it's been deeded as being part of his property. He again is the dominant servient in that. So since he's the dominant servient, that is the one that has basically kind of created a continuity between the large tracts of land down to, which therefore makes that easement part of his property, therefore abutting to the highway. And so, if anything, we go back to, let me make sure that I am stating this correctly from what was stated earlier. But that takes us back to the abut and. And so with the abut and have access, my client does meet that requirement. He does have that abutment and the access. He's following through with how the easement is stated. And so we are, I know there's been this idea of like, well, what if we move the easement and all that? And while we do appreciate that, that is not something that we have considered or looked at, because as we know, it's not considered to be part of the appeal process. And the one thing I want to urge on that is the fact that this is something that is recorded. And so the recording is very clear. And so we are asking that council follow through on the recordings, that have been provided to you, and that, council, maintain what planning and zoning put in that Mr. Ontiveros be allowed to, have his RV park, and be able to, go ahead and operate that.
Questions?
Yes, I would like for the council to be able to ask questions of this attorney if procedurally it's okay.
It's just fine. We've done it all along so far. And I might just say, it doesn't appear that you're going to have any witnesses either, Ms. Bobbin. Is that correct? The public will be allowed to testify if they want, and if the Wikis want to be part of that public to testify, they may do so. But so far, we've just had an argument from the council, myself, Ms. Martin, and Ms. Bobbin. And so the reason I didn't swear any of the three of us in, so that you know, is that we're considered to be officers of the court, and officers of the court aren't required to be sworn in for sworn testimony. That's where a witness is.
So the counselor,
On the replat that you talked about, there's this funny little triangle that abuts up against the easement called, and then there's a letter B, a circle with a letter B.
Yes,
What is that?
That just labels.
you need to put him on both if he's.
Are you going to answer that?
Yeah.
Raise your right hand, please. State your name.
Edgar.
You, Edgar Ontiveros, solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. Yes, sir.
You may answer the question.
Yeah, that's just, that gives you the radius of the curve for the road. That's it. It's just a point of
Oh, it's
reference.
just a measurement.
Yes, ma'am.
Okay, thank
Yes,
you.
ma'am.
Thank you.
any other counselors want to ask questions of the attorney?
Well, at this time, I'll hold my questions a little bit later. I've got a couple of good ones I'll back to.
Okay, sir.
So with that, do you have anything? I'll allow public comment, and then I think probably allow the attorney to do closing before we close. Let me go to public comment. If that's appropriate.
And then, Mr. Underwood, if I may.
Sure.
And so again, just to reiterate, again, looking at the replat, how it kind of makes this Y shape and there's a longer part of that Y over here. This is not to be used at all. And that is the one that takes up the majority of the Sorensen property. It is solely just this small section over here. That would be the portion that would be used for the RV park. As the easement, as you then see after that, does extend onto my client's property. Okay.
So are you saying that as I'm looking at this and it's pointing north, the easement that goes off to the right?
Is the one that would be used, yes.
And are you willing to put that limiting language into any grant? This is it's granted.
Yes, sir. Your Honor. Oh my God. Yes, sir.
I like that.
It's been big. Do you want us to stay here or do you want us?
I think you can move. Okay,
So this part is still open to the public,
We're going to
correct?
open it to the public now, and as I stated, anybody that comes up to speak, I will have you sworn in. And what I would like for you to limit your comments to, and I know it gets confusing sometimes, but really all we're doing is discussing the right to use this easement for access to a C2, and that's what was granted by the planning and zoning committee. And whether the issue is whether or not that easement, which is a pertinent to this property that purchased by the municipal RV park, can be considered to be an abutment. I think that's probably more so of a legal question than it is an evidentiary question, but if you want to address that, that's fine. So anybody want to?
Council, if I may, I just wanted to mention, and I apologize for not really, I don't do these every day, so I didn't know quite the procedure, but Ms. Sorensen did hope at one point to provide a short statement, if that might be possible at some point.
Is it? Who is it?
Melissa.
Mrs. Sorensen, Ms. Sarah Sorensen.
All right. Would you raise your right hand, please?
Yes.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Would you state your name, please?
Sarah Sorensen.
And Sarah Sorensen, where do you reside?
I reside in North Dakota.
And are you one of the owners of the property located, are you one of the appellants protesting the granting of this conditional use?
I am.
Go ahead.
Well, so I wanted to say that my brothers and I grew up in North Dakota, but my dad moved to New Mexico probably about 15 years ago, and he died last July. And so, but he lived predominantly in New Mexico, and this home that he has is kind of all that we have left of him, I guess. I have two young kids. I have one here. Addison can come. This is one. This is one of my children, and this is the other one. And so I have a big concern about the RV park because when we go to visit in New Mexico, there's essentially, you're turning this easement essentially into a big highway through his property, which is very dangerous for my children to go visit their grandpa's place. It was never used as a commercial highway when my dad used it. I didn't feel unsafe at all when we went to visit. There was basically my dad used it, and the neighbors, the Wickies, used this driveway. There wasn't many RVs going through this property. The second thing that I'd like to say is that it would be acceptable for me, at least, that the Wickies who sold Mr. Olivares the property, if they own the land next door, and if they said that they were willing to sell their land, at least at the last hearing, for the right price, and if they do that, that's acceptable, and that would provide land that abuts a major arterial roadway. So the Wickies are certainly free to do that, and that would be acceptable. They can sell their land, and that meets the requirements of the statute or the ordinance that you have provided. We're not contesting that it's a C2. We contest that it doesn't meet the requirements of the ordinance. So that would be an acceptable solution for the Wickies to sell to Mr. Olivares.
May I ask you a question?
For the safety of our family and our property.
So how often have you resided in this home with your children since your father's death?
Well, let's see. I've been to New Mexico several times since he died, but right now they're currently in school, so that makes it difficult to do that. So are you asking since he died?
I was just wondering how often you use the home.
Well, my brothers, I have 3 other brothers, and they are there occasionally to use the home.
Does the
Their
qualification,
children.
did the condition of having the speed limit on that one, you understand this is just for one of the 2 easements. Having the speed limit at 5 miles per hour, did that fall any of your fears?
No, no, it does not. I mean, there's going to be several large vehicles going in and out of there if there's 42 pieces. And that's not how the easement was ever used. The easement was never used with several large commercial vehicles. It would be my dad's vehicle going to his place, his residence, or the Wickies using their vehicle to go to their residence. It was never used as a commercial, it was never used as essentially a commercial highway going through his property. But certainly if the Wickies want to sell their piece of land and turn that into, into a highway to the RV park, that's acceptable to us. That falls within the rules from what we understand. But it's not within the rules to put a major highway essentially through our private property.
And were you aware of the fact that the property that the RV park is asking to be put into was in fact zoned commercial when you acquired the property?
Well, my father acquired the property. So are you asking what he knew?
No, I'm asking you what you know.
Wow.
Now, my acquiring of the property is after he died.
And I wouldn't ask my client to speak to what a deceased, party did or did not know. I mean, that's not my client's purview.
And I was asking her what she knew.
Well, and she didn't acquire the property. She inherited it. So, to be clear.
So when you inherited the property, were you aware of the fact that the property was C2?
The technical definition of C2? No, I mean, my dad died in July. So are you wondering when I learned the technical zoning of it being C2? Or is that your question? I'm not sure. I know that when my dad was alive, there was not many vehicles going through that driveway. It was just his vehicle. And I don't even remember seeing any other vehicle besides his vehicle use that.
Right. I was just asking.
I didn't feel unsafe. I'm sorry?
I was just asking to your knowledge of how it was zoned.
How it was zoned. Okay.
I'll move on. Public testimony? Yes, ma'am.
Hello, everyone. I'm Cassidy Meeks. I actually wasn't going to speak today.
Cassidy, would you raise your right hand, please? You solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
And where do you reside?
I live here in Ruidoso Downs at Slow Play RV Park. And that's kind of the only reason I'm speaking today. I'm actually, aside from being on the fire department here, I'm also a regional property manager for Cabin RV Resorts. So I think my knowledge might help hopefully clear up some fears that may be going on today. I have 5 children of my own. We live in an RV park with 140 spaces. I also oversee another property in Ruidoso, as well as on occasion, different ones throughout the country. We have a fenced-in property. We keep our speed limits at 5 miles per hour. Again, I have 5 of my own children who live on the property where RVs are coming in and out of. And I've never had a fear of anything happening. I think as long as the right rules are put into place, I think it can absolutely be very safe, even with children involved, to live in an RV park or near a road where there is traffic like that, as long as it's managed well. I do have park hosts that take the RVs to their spaces to make it a little bit safer, make sure that they're maintaining that 5 mile per hour speed limit. As well as there was a point brought up earlier on, I can't recall exactly the wording that was mentioned, but about the amount of RVs that would be coming in and out. So as I stated, I have over 140 spaces in my RV park alone. That being said, I have never, even on our busiest day of the year, which is typically going to be around Labor Day, I've never exceeded 40 RVs in a day, and that is with 140 spaces. With the RV park in question, with them only having 40 some odd spaces, I would not, and in my estimation, being in this business for well over 5 years now, I wouldn't assume that there would be a huge level of in and out traffic for an RV park of that size. Again, I just hope that it kind of helps with some of the fear. I think as long as the park is well managed and well looked after, and there are certain rules put in place, I think it is very safe. We live in a stucco house on the actual RV, in the RV park, in the middle of it. There are RVs in and out. And as long as it's managed well, I think it can be very safe for children. So I don't see that really being a huge, concern, as long as parents are watching their children and RV drivers, hosts are paying attention and making sure that they're doing what they need to be.
Questions?
Questions? Yes.
Cassidy, thank you for your service.
I have a question.
Sure.
Yes, I
Or,
would.
just a moment. We have a city
I
councilor
apologize.
that has a question now.
Could I yield to Ms. Martin and come back to my question?
Okay, Ms. Martin, go ahead.
Thank you, Council. I have a couple of questions. One, I would like to ask where your RV park is located and if it abuts a major arterial roadway.
It does. It is off, the address actually is 26514 US Highway 7.
Okay, so it does meet the requirement that the RV park abuts
It does,
the
that's
highway,
correct.
unlike this situation. Okay. And would you agree, I hear your point that you have a larger RV park, and therefore a larger capacity, but would you agree with my calculations that even if 10 RVs were to go in and out a day for 365 days, that would result in about 3,600 entries and exits per year?
I do agree with that.
Okay. All right. Thank you, ma'am. Nothing further.
Counselor Lacewell.
Thank you. So I just live on a street without an easement, and if I just look at the traffic that goes by my house every day, and there's only, isn't that how many people on our street? Not even a dozen, not even a dozen. And yet, cars.
Yes.
So I'm also thinking of how many times I leave my home and drive down the street, go to Walmart, come back, and oh, what, now I need to go to the council meeting, come back.
Absolutely.
So I'm in and out a lot.
Yeah.
And I would think that the people in the RV parks are not gonna go down there, although it does look like utopia down there. I probably want to go down and stay. But they're gonna have to come out and get groceries and go to the restaurants or whatever, which is gonna result in traffic. And your driveway in your RV park, do these mobile homes and mobile RVs and even their little jeeps and whatever, they have pulling behind. Do they drive on your driveway past your home where your children are to get to their?
So they do. I actually live right in the center of the RV park. My home is a stucco home right on the corner, so people pass this direction as well as this direction. Across the street from me are RV spaces, behind me are RV spaces, and all around there are RV spaces right next.
They.
What? They down?
No, here.
Sarah, did you lose contact as well?
Yes, yes.
Oh, all right, let me see if I can email Jeanette or something and let her know.
Okay, I'm gonna call her. I'm giving her a call.
Oh, great. Yeah, that'd be perfect.
Ellie, are you, Sarah Sorensen's on the line, right? Or get back.
Yes, she's on there.
Sure.
Council, we are back on, myself, and it looks like perhaps Sarah as well.
Yes.
I thought somebody was talking. Go ahead and leave, because I hate to leave Lola for too long a time.
See you later.
Okay, I love you.
Love you more.
No, I love you more.
No, I love you.
You rock my world.
Okay, I'll call you later.
Okay, darling.
Can you hear me now? Are you
Yes,
there?
we can hear you. We can hear all of you.
Sorry, we lost connection and we're on a 5-minute break.
Okay, great. Thank you.
Home or is she going?
She probably won't want to go. She'll probably be at home. So when you get done here, if you could swing by the house and wait, babysit kinda until I get there.
Okay.
Thank you.
Hey, Alan,
Yes.
I'm trying to join in because I have to go to that dead
Can you hear me all? Hear me now? Oops.
Hey, Ally, this is Knight. Can you hear me on this?
Used for individual traffic only or personal traffic only or not for public use. There's no.
Hey, Ally, this is Knight. Can you hear me?
Yes, can you hear me?
I can. I'm just making sure. Thank you. Whenever they're ready to call, I can do it via Zoom.
Okay.
Oh, thank you. Look at the water. That's nice.
I'm thinking about selling water and burritos the next one.
I'll take the burrito.
You have to get a permit. Okay. I don't know. I know who that is.
And I think a candy factory, but vending booth is about $500.
Oh, okay.
We are the only one that has a spring water. Rudoso has little spring.
You have a whole lot of burritos.
Who does?
Right.
We only have surface water. And I think
Open your card and find out.
Yeah.
Businesses.
Well, Bob Miller told me a long time ago, and he was right. That Riverside well could pump so much water again, but it's regulated.
Did he tell you also that the whole inside is?
That also about.
What is it called? Like sterling silver?
All right, let's call the meeting back to order. Meeting is called back to order. Go ahead, Brian.
Pretty good.
Really? I want to do that.
What about grandkids? Okay, I'll
We're
resume.
resuming, we got, Ms. Martin and, Ms. Sorensen back, so.
Okay, I'll loop back around on Brian Roberts and I'm on the zoning commission and resident here. My point is that in looking at the, I'm very familiar with zoning ordinances. I'm somewhat familiar with the rest of our ordinances. And it has been mentioned that it says it shall abut and have access to, but 10.06A of the overall ordinances states that the word and implies the word or and vice versa. I'm paraphrasing, but John, is that essentially what it says? So that means by that clause in the beginning of our ordinances for the city of Ruidoso Downs, that phrase can be read, shall abut or have access to. So my point is that an awful lot of the argument has been based on the word and, but in substituting the word or, it informs why our decision went the way it was. It wasn't that we were deliberately, or at least my decision, I can't speak to anyone else, but my decision on this vote was informed by 10.06A.
And the other point that I would make is that as a C2, there are a number of businesses that would not require zoning to make an approval. For instance, you could have a marijuana grow. You could have a shooting range. There are a lot of businesses allowed under C2 that would be full commercial businesses that might be much more objectionable than an RV park. Now that, my opinion, so that everybody's got an opinion. But I wanted to make the point that that ordinance can be read, shall abut or have access to. That's all I had to say. Questions? We'll look at you. Okay.
I think I'm trying, the question isn't to you, Mr. Roberts, thank you, but, John, legally, if it said or, would it, well, then automatically imply and?
But it's and or. So if you say or, it says and or. If it says and, it's and or. So the use of either one of those means and or.
Council, may I comment and read the entirety of that statement
Of the ordinance?
of the definition?
Yes, ma'am.
It says and or is the title. Either conjunction shall include the other as if written and slash or if the sense requires it. So that's not a blanket that every and or used in the entirety of the Ruidoso Downs Code of Ordinances means and or that you know simply defies logic of legal reasoning. If you can't have an exclusive or an inclusive term used in your entire laws on the record. So I would just like to point that out.
And I think what Mr. Roberts was testifying to, that as a member of the commission, that's the way that he had interpreted that particular provision. Yes. Any other public comment?
Yes.
You come forward. Raise your right hand, state your name, please. Thomas John Lewicki. Do you, Thomas John Lewicki, promise to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Yes. You may be seated. Thank you.
Okay. I'm the builder and developer of this property. Okay, and I applied by all the subdivision rules, of course. At that time, I was sole owner of all of it. Okay. Back in 2004, it was going to be a bunch of condos. Okay, this is 2004. This is when it was approved as a subdivision back then. Okay. It'll always be whoever owns the property on that property, whether it be two people or three people or one person. It's going to have the same access, the 30-foot easement, utility, and obtained road to that property. Okay, that is end of story. Okay, that's the way it was built, the way it was designed. The only way it could be designed with the way the drainage and everything else of the property. I think everybody needs to visit the property, get a visual, see what it's all about. It's the most beautiful oasis there is down there. It can only be a beautiful RV park. And I'm here at Omar and Edgar's behalf because I didn't have the money or the youth to do any more developing. I have 2 acres. Is all I can do right now. And that's all I wanted. Now, I think it's fair to where this man, he paid good money for that property. It's a very beautiful piece of property, and I think he deserves to have that property done the way he wants, because it's all dreams. We all have a dream in life, and we have to pursue those dreams. Fred Sorensen is a very good friend of mine. When that man purchased that property, I give him water. He did not have any water or any access to electricity or anything. I give him all of that because I own the property. I developed that electricity and the water to him. I give him the water until he put his own well in. Fred was well aware of the subdivision requirements and the subdivision rule. Okay, that easement, that 30-foot easement is for the 3 property owners that own it. Myself, Sorensen's, and Edgar and Omar. Okay, they own, it's the same thing, okay? And it wouldn't be a smart thing. You got 30-foot easement for that. The Harveys got their 30-foot easement for their trucks to come in. And then you want me to give up more property of my 2 acres and put another 30-foot? That's 90 foot of road. Does that make any sense to anybody here? Those roads will be all together. I think the 30-foot is plenty, okay, for everybody to enjoy it. Another thing is, the time that Fred bought that property was, I believe, around 2008 maybe, or I don't exactly remember. Okay, I have never seen his kids there until he passed. Till Fred passed. It's the only time I've seen anybody from that side of the family. And then when we went and introduced ourselves, it was like, you were like taboo to them. I had no idea what I ever did to my neighbors that.
Tom, I don't want to get into personal.
Okay, but what I'm saying is Fred knew the subdivision requirements. He knew that easement was an easement. And he owned the property. They only inherited the property. And so as far as that goes, I have every document you want and the dates of when all of this was taken care of, done, okay? And it's all on record. And I don't understand there's one thing I can't stand is lawlessness and corruption. And I feel there's a lot of lawlessness and corruption going on here. And I hope everybody gets a handle on it.
Well, I
For the best-
resent that, sir.
For the best of all.
I resent what you just said.
Thank you.
Okay, let's, does, have questions for this? Okay,
Yes.
So Mr. Swanson, to the best of your knowledge, purchased the property in 2008? 08?
I'm not sure. I know I
think I
took care of
showed you
his
the
property for 8 years.
2014.
Right.
Oh, 8 years, I'm sorry.
8 years ago.
8 years.
2014. Well, the reason I'm
So it
asking,
was, well, it was 2000, well, take 8 from 14, what do you got? 2007?
Well, he purchased the property, in 2014.
Okay,
so that's 10 years.
But
okay. But like I said, I'm getting old now and I'm forgetting how many
The property
years.
was annexed in 2004.
It was annexed 2004,
That's
yeah, commercial.
Right.
As it was here. See, actually, his house was supposed to be the office. Okay, and so all there is, just like you said, there's a little peninsula
Yeah.
there and a peninsula where his barn is. Everywhere else is easement. I give that up when I owned it. 30-foot all through the whole thing, so I could do this subdivision back then, but the village couldn't produce me water. Okay, now we have the water. We got a 6-inch line there. Okay? And Omar and Edgar, they have the water, they have the water rights. All they need is pump that water, put that water down there and I just, they got a beautiful design, even better than I was gonna do. And I'm just here for their support.
does any other counselors have questions, at this time?
I do, council.
Just a moment. Counselor Lacewell.
Maybe for Joe. Joey,
Go ahead and testify.
I'm sorry, Joey. You don't.
I'll let them, as soon as Tom finishes his.
I'll wait for my question. So I yield to Ms. Martin.
Okay, and thank you, sir.
You're welcome.
We have
Thank
one
you.
more question.
What?
We have one more question.
Yes.
Council, and I apologize. When you say counselor, I think you're talking to me, so I apologize for butting in on y'all, but we're all council here, so I do apologize. But Mr. Lewicki, now would you enjoy having the RVs crossing across your property, and is that something you would want on your personal property?
Of course.
Okay, but yet you're not willing to grant an easement or sell your own property to grant excuse me, I'm still talking, to, as you said, fulfill the dreams of the owners of Excalibur.
I already did. I granted all the easements. I was the sole property owner. I put these easements in.
Right, but they don't have an access point to the highway through your property,
Yes,
correct?
they do. They go right to the highway.
Okay, they access.
Have you been to the property, ma'am?
Council,
Have you been to the
sir, you're not
property?
answering my question. You're being combative. If you don't mind, I'm just asking you a question, whether there's access to the highway purely through your
Yes.
property.
To the highway, yes.
Okay, so all RVs can avoid the Sorensen property and get to and from the highway from your
Yes.
property.
Yes, they're actually, well, it all depends if they open up the other. They only wanted one easement, but they have two easements.
Sir,
The
you're still
Sorensen
not answering my
property is a
question.
peninsula. It's on the top of a hill and it's cut into the hill. So the property anywhere else is nothing but an easement. It can't be used as anything else.
And
You
sir,
have to see
okay,
the
we'll
layout
assume you're
of
not
the
answering the
property.
question. And would you agree that the property that you sold to Excalibur, the title you granted to the buyers, that no portion of that land touches and abuts the highway, that they do not own title to any land abutting the highway, is that right?
They do own it. It's the easement. It goes
They
to
own
the
title
highway.
to the easement?
Yes,
They hold legal title
I
to that
am.
land?
They are, and so is the Sorensens.
Okay.
Okay,
Okay, well,
it's
I think that's where some of the
one
confusion
entry
is.
into the whole subdivision.
I think that's where some of the confusion in this matter comes from, because, sir, I'll tell you, they do not own title to the easement land. They do not own title to that land.
Yes, they
No,
do.
nothing further. Thank you.
Mhm. I'll let you guys argue it out, because I'm not qualified. Thank you very much. You have a question for Mr. Lewicki?
So just to kind of clarify first, so what I have pulled up is I'm back at the replat of the Lewicki Land Division Tract 2. If anyone feels like following one. And so just to clarify, because I think maybe there was a little misunderstanding. So Tract 1 here, is this the Tract 1 here, and just to be aware, the large document he is looking at is the same document.
I can't see the
that
small print. Is that the one that says replat of Lewicki?
Land Division Tract 2. And so Tract 1, who owns Tract 1?
The Sorensens,
Okay, and then who owns Tract 2A?
Stephanie and I.
Okay, and so the easement, as we see, there's a bunch of notations as to degrees and inches and stuff like that. And so what we're looking at that runs from Tract 1 up to where it says one in large letters, it says 199.61 apostrophe. That section that's running between, is that the easement that we're
Yes.
talking about?
Yes,
And is that on your property?
yes, it is.
So the RVs will be passing on your property
Yes.
as well in order to go onto
Yes.
Monteveros? Okay.
Yes.
And so
And they could use this one too, because it's recorded.
yeah. But we have talked that would not be utilized. So we have one small section here, and then we have one section that comes across,
Okay,
right?
can I ask you a question?
Yeah.
Okay.
And so, no questions to me. I only get to ask questions. And so here, so the RVs will come through Sorenson and they will come through your property?
Yes.
And do you have an issue with the RVs
No.
coming through your property? Okay, no further questions.
Are we done? Anybody wants any questions? Thank you all.
Well, thank you for your input and,
Joey?
Good. Well, she needs to-
Council, will there be time for closing arguments?
Can you wait for just a second?
Yes,
Councilor Lacewell has a question of Director of Parks and
Parks and Rec, sure, that works too.
Parks and Rec.
All of it. I don't know.
I've seen that on TV.
Public Works Director.
Whatever you want to call me.
I call you sir. You solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, sir, I do.
State your name.
Joe Jarvis, Public Works Director.
Thank you, Mr. Jarvis. I was wondering about the well. So if Mr. Swenson bought the property in 2014, how was he authorized to put in a well?
That I don't know, because we have a city ordinance that states that that's not allowed. That was before my time as a director. I don't know. Mr. Lewicki might be able to answer that. I'm not sure.
Could that be something that Jeanette could research about how they were able to get a permit for a well in 2014?
That would probably be right near the OSC.
The Office of the State Engineer. We don't issue those permits. You have to go to the state to drill a well permit.
Well, but you can deny it because we tried to put in a well.
We do not have our ordinance says if there's water available or sewer within, I believe, 200 feet, then you must connect and you can't drill a well and blah, blah, blah. I've never seen anything that says we can deny it because the permit doesn't come to us. The well driller gets a permit, goes to the state, comes back to that well driller and he goes to work until it's caught.
I can testify that the
So if he's
city,
caught, yes.
the city denied it. Okay.
Yes.
So then the question would need to go back to Mr. Lewicki.
Maybe he might know about it because he was the one that had the original well and let Sorenson have the water.
Okay, thank you,
Hey, any questions of Mr.
Jarvis.
Sir? You're excused.
Oh, just a second. Counselor Proctor.
In water supply, the RV park.
Yes, sir. RVs use very little water.
Okay, it comes from the city.
Yes, sir.
Okay, thank you.
Joey,
We've already had a talk.
Joey,
Yes, sir.
I had never heard you say, I don't know before. You always have an answer and it's correct. I finally heard you say, I don't know.
No, because I can speak a lot on this. I
Okay.
walked Mr. Lewicki's property. There's no place to put an easement. On the east side, it's impossible because there's property that their houses are built to both fence lines, so that ain't gonna work. The easement is the easement. And John, you might look at, the easement situation that Riverbend was built because it's an easement just like this. Then RV park was already built that in 2003 or 4.
That was meant as a backdoor compliment.
Well, I always got something to say.
That was
You ask it.
and backdoor testimony.
He is awfully good.
Do you have a question, Mr. Louis?
Oh, can he, do you know?
I can
Okay.
come back up there.
What's the story on the well in 2014?
Come on, wait.
Mr.
You're
Sorensen,
still under oath. Tom.
yeah, Mr. Sorensen, put a well down there.
In 2014?
You didn't have water there yet. That's why.
We didn't have water for him there, but I mean, I would have given him water. It was, already piped into the house. But, he wanted to do his own well and actually, the Sorensens bought, Draper's property also. So they have 1, 2, 3, they have 3 homes on the east side of me. Plus, he owns a 250 barndominium that I built him over in Arabella, and plus has 2 or 3 ranches down the valley. So they have a lot of ranches for their kids to go to if they want to. If they're afraid of the RVs, I guess, I don't know. They have other properties.
Counselor Lacewell.
Thank you, sir. So is your personal home also on the well?
Yes,
Okay, thank you. That's that.
yeah, it's been there since the 50s.
Okay,
And it hasn't changed any level at all. It's been the same as it's always been. It's a Deming Stream that runs through there, and it's great water.
You sell it.
Huh?
You sell it.
Thank you. Any other questions?
No.
Thank you again. Still open to the public.
Anybody else?
Okay, we close it. to-
Martins, you want to give a closing statement?
Yes, council, I sure do. And you know, I hate cheesy closing statements, but I think in this context, it's very applicable. That old phrase, the road to hell is paved with good intentions. And the reason I say that is because your zoning commissioner came up here today and articulated that his assessment of the language of the Code of Ordinances, the meaning behind this limiting language was to prevent the placement of RV parks that cut through residential neighborhoods with multiple families using them, that sort of thing. And I would implore you to consider that by determining that abutting, or rather having an easement to a major arterial roadway is enough to qualify as abutting and having access to a major arterial roadway, you're doing exactly what you're trying to prevent. The next party that comes is going to say, no, I have a public easement. I go from my property down Avenue A, I cut over to Avenue B, cut over to Avenue C, and there I'm at the highway. That a public easement is a right of access, just as the easement we're looking at here. And so I would truly implore you to consider the ramifications of considering any easement access to a highway to be sufficient to place an RV park. As an attorney, I would be all over that with my next client saying, absolutely, you qualified for a recreational RV park on your 2-acre parcel up the road through this residential neighborhood. And it will now be the city council that is rewriting the city ordinances and determining who abuts and who doesn't by using, you know, there's no fair way to interpret giving one party saying you abut because you have an easement, but not giving it to the next party that has a public easement. That's the way it's going to play out. And I would make that legal argument all day long. This property does not abut a major arterial roadway. And as your zoning commissioner stated, this is exactly why that language is in there, is so that you don't have, you know, RV park access cutting through properties with children or neighborhoods or the like. And it may be unfortunate, as one of the zoning commissioners stated in their hearing, may be unfortunate that there's the term abuts and has access to. But that's the way the code is written. And it's not for me or you to simply rewrite it as we see fit. So I would implore you to look at that language, consider what it's going to mean for the community when you just disregard one of those two terms, and consider that fully before you make a decision to allow this, because I think you're opening Pandora's box. Now, considering the easement, I will close by giving you some language straight from the New Mexico Supreme Court. I love quoting to them because there's no higher authority in the state of New Mexico. And what they say is a preference exists in New Mexico to narrowly construe the rights created by an easement. That's in Walker v. United States from 1981. They continue that the New Mexico Supreme Court has noted that, quote, the law is jealous of easement claims, and the burden is on the party asserting such a claim to prove it clearly. Now, I would consider whether Excalibur in this case has clearly proven, simply because this property is zoned C2, that you are permitted as the city of Ruidoso to permit RVs, campers, trailers, what have you, in and out of this property, and that is sufficient and that is agreeable in scope to what has gone on that property for the past 20 years. I like to listen to the Supreme Court of New Mexico. It says to consider these easements narrowly, and I would encourage you to do the same. Thank you so much.
Thank you.
Ms. Bobbit?
I'm sorry, was there a question for me in there?
No.
No.
Thank you.
No, one last time to get your. I did enjoy the road to hell is paved with good intentions. Because we're not looking at intentions here, we're looking at fact. And the, the idea that we are using public roadways to be something that we're then attacking you with, claiming that, well, if you grant this deal with this easement, that then any house that is up against a public roadway is up against an avenue or a road or you know, a city-owned property, will give everyone the ability to put in RVs, and RVs will be everywhere. How dare they? That's not what we have here. We don't, that doesn't exist. And so when someone is trying to make you feel like you are rewriting ordinances or you're rewriting things, that's not what you're doing. In this situation, it is abundantly clear that you are being asked to uphold the ordinance. And in whatever way it is that you decide to make that decision, obviously we want it to be made in ours, but we do want to make sure that the facts are very clear. And it's not, you know, there's this claim that this is a legal argument that will be made all day. It's, again, it's not legal. It's a factual argument. When you are granted an easement, you own that property. When you live in a home that is on Avenue A that connects to Avenue B, that connects to Avenue C, you don't own those roadways. Avenue A is not yours. Avenue B is not yours. You pay taxes on them, but they are not yours to maintain. They are not considered to be part of your property. You don't have deeds to those properties. You don't have deeds to those roads. With my home abuts up to a public roadway. I don't have any deed that tells me that I own my roadway. This situation is one where there is ownership of a roadway. The city of Ruidoso Downs does not own it. It is owned by my client. He is the dominant, and this is where, again, the dominant and servient thing really comes into play, because the property is property of the Sorensens that has been and property of the Lewickis that has been granted to now my client's property. And so he maintains, he's the one that takes care of that road. That's not going to be a responsibility of the city of Ruidoso Downs. And so to kind of put this idea of fear in you that all of a sudden all residential neighborhoods will have RVs in them because that's what you're setting up. You're not setting up that precedent. You are following through with the ordinance that you've been provided. And if you make the decision that a privately owned easement is considered to be abutting up against a highway, and that someone owns that easement, so therefore that is considered to be abutting and access. If you make that decision, then that is what is upholding here. It's not that you're reworking or rewriting. And so obviously we implore you to understand or to ask or to find that the privately owned easement that is maintained by my client, that is deeded to my client, that is considered to be part of my client's property, that is property of his that abuts to a major highway and therefore allows access. And again, when it comes to the RVs and again, this idea that they're being thrown up everywhere, it's very clearly stated in the ordinances in section 155.083 that in order for there to be recreational vehicle park developments, they have to get a conditional use permit. So all RVs have to come before the city of Ruidoso Downs. either the Planning and Zoning Commission, and then if appealed, obviously too, but it has to come before the city. And it has to be agreed to, voted on by the Planning and Zoning Commission that you all have in place. And if not agreed to, brought to you by appeal. So the city of Ruidoso Downs, in their ordinances, has themselves that you have to approve every single RV park. You don't necessarily have to approve every business that goes in. I know you have to get business permits and whatnot, but it's very, and then even with that, with the recreational vehicle, it goes into the whole list of guidelines as to what has to happen here, that it has to be 27-foot road. You have a 30-foot road in this situation. You know, where your setbacks are. And that, again, this is only something that can happen in a C2. This is not something that can happen in a residential. And so I just want to make it really clear that the idea that now all of a sudden, if you do pass this, you're looking at tons of lawsuits or tons of asks for RVs and all this, and that you'll have to grant them because of the precedents you set. It is not the same as the situation you have before you. And so I just wanted to make sure we got that really, really clear. And so again, we're just asking that you uphold the ordinance as written, finding that the easement itself is owned by my client, therefore making his property as deeded and therefore does abut and have access. When we're talking about the New Mexico state law and Supreme Courts and all of that, again, you know, here it's interesting because, you know, if you're in court, then, you know, we make these arguments about, well, the New Mexico Supreme Court said this and that, and then we'll have judges that will find other cases or find mixes in terms of what is clear, you know, clearly stated, and then the judges will render their opinion. Here, and it does state, I have the case where it does state that there's a preference exists to narrowly construe. It's the burden on the party to prove clearly. Now, interestingly enough, when I was looking at the cases that supplied that information, there are several of the cases that were listed in your appeal that when you look them up, have negative treatment. And what that means is that the holdings in those cases that did say these things were actually found in other cases to not be followed because they were not considered to be law that the Supreme Court, bless you, that the New Mexico Supreme Court wanted to continue to follow, or they felt that there needed to be an exception to that. And so when you are reading your appeal packet and you see the listing of the cases and you see what's referenced in them, one, those cases, again, are very different than the situation we have here. And I'm not expecting everyone, I got the cases. If you want to read 40+ pages of case law, I will more than happily give it to you. However, I urge you to read that with caution, just because, again, not all the cases are just fully accepted. New Mexico has found that the cases that are referenced are negatively treated later, so not completely followed. And then additionally, that's not something that necessarily dictates the end all be all, right? And it's also something that without knowing the extent of the cases, like one of the cases is a water drainage case, which is not applicable in this matter. Another one is about how a roadway was square and the court turned it into a non-square roadway. And so it was an easement. They made it from being a box to being a curve like a roadway does. And what I found actually interesting is the majority of these cases actually found in favor of the people that had the easement. And so just something, a grain of salt to kind of take with that when you're reading. But either way, even if we do follow those things, the preference that you narrowly construe is then that you have to narrowly construe, which means that where it states easement B on the replat, where it says access and utilities, you have to narrowly construe that, which means if the easement is allowing access in and out, then the easement is doing its job. That is the construction of the easement. That is the purpose of the easement. My client meets that as the easement is being used for access in and access out. So if you're narrowly construing, he does meet that requirement. And then on the burden on a party to prove a clear reference of the easement, we have C2 property, we have an easement on C2 property, the easement is allowing access. And so my client today has shown that burden of the fact that the easement is for access and it's for utilities. And so even if if you read it and you're like, you know what, I do want to follow this rule, the law, the way that they have listed it, then my client does meet those two burdens, those two clear burdens that they have set forth. And so again, we are asking that you are not rewriting, that you are taking the ordinance, that you are applying it as it is written, and that in the facts that my client privately owns and has title to is deeded the easement that is considered to be part of his property, that is considered to be abutment. And then, and actually, like, one of the really good points I heard was, what other business would you want in there? It's not going to sit, right? It's a C2 property. Someone's going to come in, someone is going to put a business on there. If it's not an RV park, if you're not okay with the RV park, in your mind, your worst case scenario, are you okay with your worst case scenario business being in that area? Whether it be a marijuana shop, whether it be a shooting range, whether it be whatever your mind can conjure, right? And so is an RV park compared to your worst thought of a business being on that property, which one's sounding better? And so, I can say my client has in the appeal packet, we have submitted what the structure, what the layout of the RV park will be. It has passed the conditional use permit as it was required to do. My client, like, we've heard that there is this oasis. We're just trying to create something that can kind of, obviously make a profit on Oasis, but also create a refuge for people that want to come to Ruidoso Downs, Lincoln County in general, and have somewhere beautiful that they can set up and relax. And if they, and even if it's long-term residents, same, maybe, as we've heard earlier, maybe having some families there, maybe having, families that stay for an extended summer, et cetera. And so, while, there can be the idea that people, are hesitant to RV parks, kind of thinking about the beauty that an RV park could bring as well. And so, my clients, they want to make sure that we thank everybody for letting us be here today, for hearing us out. We know that you do not have an easy decision before you. You've been attacked with a lot of information. And so, we ask, obviously, that you find our favor and grant the RV park. Thank you.
Before we go, Mayor, may I ask? I have a piece of property and we bought 4 acres behind it and it came with an easement and it would have been literally just right on the property line. So we moved the easement to the other end of the property and with agreement with the people that we bought it from. I don't remember a term like legal title to easement, but somebody has access across my property. If they need it in the future, there's an easement and I know it's there. Where in we have 77 pages of documents that we look at, and I'm sure that there's a title somewhere, a deed. It says that there's legal title to easement, and I'm wondering if you could help me out or letting me know the title.
Sure, that one's titled the grant of easement. And let me see if I have. Giant stack of art. Let me see if I have a page.
And council, if I may at some point comment on this as well, because I think it's critical to this discussion and frankly, a misstatement of the law.
At a certain point, we're going to have to put.
Yes, I understand that, sir, and I really think this is a clear misstatement of the law and it needs to be clarified, and I want that to be on the record, please.
I would like to say it's on page 16, but is it okay if I approach? And let me show you what it looks like this would make.
Okay.
So it's the one that looks like that.
Oh, what's one of those?
Yeah, and then it says in grant of easement, so.
Okay, I'll look for that one. Okay, all right, thank you. Sure.
Ms. Martin?
Yes, council, I'd just like to clarify, and I mean no disrespect to opposing counsel, but this is a very fundamental concept in property law, and I'm concerned that this hearing has gone so sideways that we're now alleging that there is ownership rights associated with an easement, that he owns title to this property. And I would like to very clearly state, pursuant to the laws of New Mexico, an easement is a right to use another person's property for a specific purpose, but it does not equate to ownership of the land. And it is a non-possessory right. So I want to be very clear that that is exactly what makes an easement rather than property owned by Excalibur. Yes, the easement right is conveyed under the deed, but that does not mean he has title to that land. He has a right. That is fundamental to this discussion, that he owns no title to the property that abuts the highway. So I want to make that very clear. That is a very fundamental principle of property law, and I'm sure the city attorney would agree with me on that. But there is a difference in a right and title ownership of that land.
Okay, my turn, and I'll be quick. It is a non-possessory right, but I would argue that, and this is under City of Rio Rancho versus AmRest Southwest, 150 New Mexico 428, that an easement is appurtenant. It passes with the land to which it is appurtenant, and to which it is created to serve the dominant estate. So it's a non-possessory right, but it's a right that passes with that piece of property. It's a indisputable right that goes with that piece of property. So the argument that it's ambiguous, in my opinion, begs the question, because it's so non-ambiguous, it's clear as the nose on your face. It says a 30-foot wide easement for access and utilities. So oftentimes we run across easements that says for use by, for personal use only. Some of them say for commercial use only. Some of them say for no commercial use, okay? But there is no such limiting language on this grant of easement. It's an easement that says it's for access. So it's council, it's the city's argument that when one acquires a piece of land with an easement on it that is zoned for C2, it's for use for that piece of property. And I believe that it grants an abutment to the arterial road. I guess on the other side of the coin, say the wonderful thing here is that it is a conditional use and it has to be granted, because the unconditional uses that can go into this parcel next month when the current owner sells it, if this doesn't go through, are automobile, boat, recreational vehicles and sales, automobile upholstery shops, churches, entertainment, essential public utilities, hospitals, medical clinics, metalwork and machine shops, hotels, motels, cabins, bed and breakfast and other such lodging establishments, radio and television studio, rental stores, restaurants, bars, packaged liquor sales, retail sales services, schools, instructional service establishments, small engine repair, engraving shops, and pawn shops. None of those require conditional use. It's one of the beautiful parts of the city code is that the conditional use gives this council the right to grant use of that property with certain conditions. And what the planning commission did was grant use of that piece of property based upon abutting being the right of an easement that goes with that piece of property when it's transferred of record. Whenever he transfers that easement goes with it. It's a right. It's a non-possessory right, but it's a right. So the this was limited to a 5-mile-an-hour speed limit. And I don't know how far you can spit, Counselor. But, if you can spit on it, that's fine. But it doesn't matter in that it was bought with that easement. The easement was placed on there prior to the protestants, the applicants, the appellants acquiring property to it. So they acquire, whenever you acquire property, you acquire it as it comes to you. And so that property came to them as C2 with all the rights inherent within our planning code. And the applicant has filed an application for conditional use. Planning Commission heard that application and granted that application. And the appellant had a perfect right to appeal that to this commission, and that's what they have done. But I would ask the council uphold the decision of the Planning Commission and grant the conditional use. I might say that you've been inundated with a lot of information today, and if the council wants, I understand that you can withhold a certain period of time in which to render a decision if you feel that's necessary, or if you wish to go ahead and render a decision today, that's fine too.
And Council, if I may respond, I would just say that, you know,
Ma'am, we've responded over and over again. Time for argument is over.
Counselor Proctor, you have the floor.
Thank you, Mayor. Well, when did your client start seeking purchase of this property? When did you start looking at the property, sir?
I remind you, you're sworn in.
Okay, last year. Sometime last year, probably from July forward.
In 2023?
Yes, sir.
Okay, thank you.
Okay, yes, Counselor.
I'd like to address the other counselors. I know that Counselor Miller and I have seen this property and I would like to see it. I also want to study and investigate the ordinances that we have, the terminology, words like and or. And so personally, I'd like to postpone the vote on this to the next city council meeting, and I'm just wondering what your input would be.
Yes, sir.
One quick comment to your question. When I bought the property, in the ads and everything where it was posted for RV use. So it was heavily,
I understand. I was just curious, sir, when your interest would come for that property to put an RV park in. That's all. Thank you.
Council, for the record, I'd just like to say that there was more I would like to address the city attorney's statements, and I was unable to do so, but I would like the record to reflect that request was denied.
Well, how long will it take?
Just one moment. Just one moment. I just want to state that I'm also looking at City of Rio Rancho v. AmRep Southwest, and I would state in response to your claim over and over again that the zoning controls that I have seen no case law presented to state that the zoning of a piece of property is the manifest intent of the parties. And the case that you so aptly cited states it sets forth the principle that an easement should be construed according to its express and specific terms as a manifestation of the intent of the parties. Now, again, I have seen there's this rush to say that because a property is zoned a certain either residential or commercial, apparently in Ruidoso, that means that anything that falls under those zoning ordinances flies on an easement. And I would just strongly, strongly oppose that notion. That's not how New Mexico interprets easements. It's not, I can tell you from looking at the case law, when you look at a residential easement, there is a lot that goes into determining the scope, not just the zoning of that property. Thank you.
So as long as you had a shot on it. I think the manifest intent is stated by the easement itself. It says it's a 30-foot wide easement for access and utilities. I don't see any limiting language in that for residential.
Which is why I would go to the surrounding circumstances. Thank you.
Which is C2 zone.
Mayor, would it be okay if I made a motion?
Yes, it sure would.
I move that we postpone the vote on this issue until the next city council meeting.
Second.
We have a motion and a second to postpone the decision until the next council meeting.
Counselor Miller,
Aye.
Counselor Tucker,
Aye.
Counselor Weaver,
Aye.
Counselor Laceworth. Aye. Motion carried.
I do want to say that if any of council want to present a written document to the council, they're free to do so. They need to give opposing counsel and other counsel a copy of that, and that needs to be done within,
Like you said, 45 days.
well, we're
That's the decision.
Decision till March the 11th. So if you want to present something to council by March the 4th for them to review, that's fine.
If I may, I was gonna hold off maybe until this next meeting in this case. Just something for the counselors to consider. You know, you have to do what your good judgment and facts, you're gonna be voting on that. Hopefully nothing emotional on it. But as you do this, and I think it should figure in somewhere in this. You're on the planning and zoning committee, and you get overruled by this council. I'm coming to you as, not as a former counselor, but as a mayor that has a lot of problems that you guys don't. You're running the risk of certainly hurting morale, also running the risk of those committee people just walking off. They think, because I've seen this on the edge before when I was on the council. You got to do what you got to do. But if there's any stretch in there, keep in mind that you're dealing with a committee.
And Mr. Mayor?
Yes, sir.
As I respect you as Mr. Mayor, I would just have to ask the council to strike your remarks. This is to be considered on the facts and the law itself, but not on any sympathy or issues concerning the committee's decision.
And I understand. I guess what I was trying to say, if there's a doubt one way or another, and you're, okay, let's move on. I think now that that closes it as far as the public.
And Ms. Martin, you understood that if you get something into Ms. Giron, or I guess Jeanette, by the end of business on March the 4th, if you'd like to have that distributed to the council, that's fine. And copy myself with it, please.
Okay, that
Is that acceptable?
Thanks, somebody.
Can you hear me? Ms. Martin?
I'm
Can you hear
sorry,
me?
I did not hear that you were speaking to me. What was that? To get a brief in by March 4th?
Yes, ma'am. And copy Ms. Bobbitt and myself with that and get it to Jeanette so she can get it to the council.
Yes, sir, will do. Thank you.
Thank you.
Did you have something else, Counselor?
That man back there keeps open if he wants to.
We have closed that to the public, haven't we?
Yeah.
New business?
All right, we're ready to go to new business. And counselors. Counselors, probably 6 or 7 minutes before the council meeting, I got a call from the chief of police. That's where he has been, is on a sensitive issue concerning our police department. The deputy has been trying to run back and forth on the thing. And so the police chief, just before this meeting, requested that we move item D under new business to the very first action that the governing body would take to free the police department to take care of business. Yes.
Mayor, I'd like to move that we move letter D up to letter A in order to facilitate what's going on with our police department.
Second that.
Counselor Weaver?
Aye.
Counselor Miller?
Aye.
Counselor Lacewell?
Aye.
Counselor Proctor?
Aye.
Motion carried.
Okay, under new business, I have asked the Mayor Pro Tem to help again. I'm on the Joint Use Board for the treatment plant, and that entity does this to an extent. They have somebody that does part of the agenda. So Councilor Miller, would you do what you did last time under new business?
Yes, I will.
I would appreciate it.
Okay, 10, new business. A is discussion and possible action on approval of agreement for the All-American Park paving and drainage.
Letter D.
We just moved.
Yes.
D.
Oh,
Yeah.
move D, I'm so sorry.
Yeah. Just-
Okay, now I got it.
No problem.
Got it.
No problem.
Okay, we're going for D.
Yes.
Discussion and possible action on approval of a law enforcement retention fund grant. And
And for information, you can get the deputy chief.
yes, for information, Deputy Chief. Please,
Thank you,
I'm sorry.
Mayor Pro Tem, Mr. Mayor, Member of Council, go ahead.
I move that we open the discussion and possible action on approval of the law enforcement retention fund grant.
Thank you.
Second.
Okay, just apologies for moving everything up. We do have a sensitive call out there where somebody unfortunately lost their life, and we're working on that one.
Roll call for the motion.
Oh,
Counselor Weaver?
Aye.
Counselor Lacewell? Counselor Proctor?
Aye.
Counselor Miller?
Aye.
okay, as I was stating, I'm recommending that you guys vote in the law enforcement retention fund. Notice to disclose monies for a grant that we applied for the city of Ruidoso Downs police officers. The total amount for the grant is $3,290.56 to be payable by the end of this fiscal year, which is July 31, 2024, to the officers that qualify. This is the unfortunate caveat in this. I'm the only one that qualifies because the Department of Public Safety's retention grant had a rule in it that says that the officers to be qualified, one of the rules was for the officer to be qualified, they had to have been working for their current department for 4 years or more. And I'm the only one on this current department that's been working for 4 years or more. Everybody has slightly under 4 years or even less than that. We did have another law enforcement retention fund that we missed 2 years ago, unfortunately, because nobody communicated it to us. That was through the DFA. That was actually for all officers. We missed that one. That was a one-off grant, but according to some folks up in Santa Fe, they might bring that grant back to legislature to put that one back in. So I'm hoping that happens. But in the interim, I'm asking that we approve the grant monies for the funding of the law enforcement retention fund to the officers that are qualified.
Question, you're the only one qualified. You gonna get the $3,306?
For
Thank you
what?
for your service.
For, it's a retention fund. It's that all officers that qualify, unfortunately, would get that amount.
If you don't get it, you gonna quit?
No,
Okay, that's all I want to know.
no, and I actually agonized over not bringing it to the council because, but I did talk to all the officers and I told them, I said, you know what, I'm not gonna do it, I'm not gonna do it, but they all said, nope, you're gonna do it. So,
Buy them all pizza.
I will buy more than that, but like, just as a caveat to this, I talked to the gal that's in charge of this, of allocating the monies. They, at the time that we found out about the grant, they were pushing to the state legislature, the possibility of amending this type of grant, not just be for people that have worked for that particular department for 4 or more years, but that it's actually council laterals and anybody else that.
Make sure they do stay.
Correct. Correct. And, but I don't know whether that was voted in the affirmative or not. I haven't spoken to her since. I'll stand for questions. There it is.
Okay.
We already had a motion.
Already had a motion.
Well, the motion
Roll-
was for discussion.
Discussion.
So I move that we approve the law enforcement retention fund grant.
Second it.
Counselor Miller,
All right.
Counselor Faber,
Aye.
Counselor Dayton,
Aye.
Counselor Proctor,
Aye.
motion carried.
Thank you.
Okay, now you're back to item
Back
A.
to A, okay. A is discussion and possible action on approval of agreement for the All-American Park paving and drainage project. Joey, you're up. He wants to.
So I'd like to ask y'all to make sure I'm not at the end of that again.
Oh,
That is a long drawn out process.
yes.
Mayor, I move that we open discussion for the possible action and approval of agreement for the All-American Park paving and drainage.
Counselor Proctor,
Oh,
Counselor Miller.
Okay,
Aye.
Counselor Faber,
Aye.
Counselor Dayton.
Aye.
Motion
what
carried.
it is, Joey, you and I being on the joint use board, we're still doing it the way that I had been doing it. They're still doing that way, and the president of the municipal league is the Ridosa mayor. They're still doing it, and that's confusing me a little
It is
bit.
me too, because to me, you would want to know what I'm talking about before you make a
Yeah.
motion. And prove that I don't know Robert's rules.
Well, that's why we call for discussion.
You can do it either or,
You don't,
don't matter how
up there, we talk first and then
it's easier the other way, but.
it gets confusing talking in two different places. Anyways, before you is the bid tabulation. We went out to CES and statewide price agreements for the paving of All-American Park. Renegade Construction was the cheapest bid. There was CES and,
They beat White Sands?
yeah, that's pretty, well, White Sands is. Zeke and them, they still, what they do is get somebody like Renegade to charge more.
Oh, I
But
Yes, they beat White Sands.
yes, they do. That's good.
So.
They're a general contractor more. And it surprised me that they beat Mesa Verde. And Mesa Verde is a manufacturer of the material. But they did. And the engineers went over their numbers, their quantities, everything jives. Yeah, we'll do, the base bid and we'll do the alternative 2, which would be the west side of the parking lot. We didn't have enough to do all 3. There's about 35,000 left over in the grant, so I asked the state, I'm waiting for an answer, and if I can pay the other one that we couldn't get done with this, if I can use the 35,000 to pay it myself. And so I'm waiting for an answer on that, but if not, we'll return 35.
But this is the senior citizens deal.
Yes, sir. Sidewalk all around it.
question. Joy, on this, who's gonna be quality control? Well, that one starts for drainage.
They have their own quality control. We also have an agreement with the engineer for oversight. And then also myself for Israel will be over there also.
I just think if the engineers are gonna be oversight on that.
Yes, sir. We've gotten now where we use them like once a week or once every 2 weeks instead of paying them to be here every day. So we do a lot more of our in-house, but we'll keep an eye on it.
Have you ever used these people before? No?
Renegade, they did all the work, majority of the work in all the roadways.
Okay.
Oh, I know who you're talking
Maybe
about.
the next 2 will also.
They're out of Albuquerque or somewhere?
Cruises,
Cruises.
they're all from Captain, but
Yeah.
they read cruises, yeah.
I had one question. I don't want to take up time though. Are they gonna ever move that electric pole from the middle of the parking lot
No, because the estimate was close to $50,000
to move it?
So that's why the pole's staying in the park.
We need to do something around it.
Maybe.
The problem is
It's flying down through there.
it's moving it, but then also if you cut it loose, you have to update the building to the new building codes. And that can get dearly costly with everything.
For the
I-
senior?
Yeah, and we
I
own that
mean-
building.
Yes.
I mean, just something around it.
Well, this new one will have, it actually has a concrete island kind of deal around it, striping, so you shouldn't park there.
Okay, something.
Shouldn't be.
Man, I'm still parked there.
Okay.
And so I'm asking if y'all will approve this and give the mayor the authority to sign the contract when it comes in, if there is a contract.
I make a motion to, okay,
The pricing agreement,
the pricing agreement, so the mayor can sign it when he comes in.
between the city of Redosa Downs and.
Renegade Construction.
Yes, ma'am.
We have a second?
Second.
I guess I could have.
Roll
Counselor
call.
Baseball. Aye. Counselor Weaver.
Aye.
Counselor Miller.
Aye.
Counselor Proctor.
Aye.
Motion carried.
Okay, Counselor Miller, proceed.
Okay, and we need Joey back up. He's still up there. B is discussion and possible action on approval of change order number 1 to La Luz Dirt and Paving LLC to correct quantities of base course on the Colonias CIF 5789 project in the amount of $30,548.44. May I have a motion?
We open this discussion that you stated.
Second.
Counselor Proctor,
Aye.
Counselor Miller. Counselor Miller,
Aye,
Counselor Weaver,
Aye.
Counselor Lakeland.
Aye.
Motion carried.
my ears are.
What are they doing?
Okay, so this, when we bid out the, east and west circle job, they didn't put enough base course in the engineers didn't put enough base course in it.
In what?
Put enough base course on the roadway. They put it out in specs, it's 6-inch base course, 3-inch hot mix. They didn't figure the numbers properly, so when the contractor got it, he said, there's only enough base course for like 2 inches. So the engineer had to come back and fix our quantities. And of course, we get to eat that, but it is all paid for out of grant. It ain't costing us anything. That's contingency funds. We always have contingency to try to cover anything that can happen.
And this is for where?
It's gonna be east and west circle. It's the Heights area across the racetrack.
Oh, okay.
The job has been delayed since October because we can't get materials. Now we're finally, towards the middle of March, they're supposed to break ground up there.
Make a motion to approve that, approve the change order number 1 to the La Luz Dirt Paving LLC. Correct quantities of base course in the Colonias CIF 5789 project in the amount of $30,548.44.
Second. Okay.
You second it?
All right, yeah, I did.
Counselor Baseball,
Aye.
Counselor Weaver,
Aye.
Counselor Miller,
Aye.
Counselor Proctor.
Aye.
Motion carried.
Next item, Counselor Miller.
Okay, C is discussion and possible action on approval of resolution 2024-07, a resolution authorizing the submittal of an application for the 2024-2025 New Mexico Department of Transportation municipal aerial program funds for street and drainage improvements within Rio Doce Downs, New Mexico. May I have a motion?
I have, make a motion to discuss the possible action on resolution 2024-07.
Counselor Proctor,
Aye.
Counselor Weaver,
Aye.
Counselor Miller,
Aye.
Counselor Baseball.
Aye.
Motion carried.
What is it, Joey?
This one is, we paved most of the roads north and south going through town here. So now we're starting to work our way from the highway up. This is for a map, with a map grant agreement with DOT. It has to be a road that's either meeting highway 70 or a bypass for highway 70. Right lane is just the first start of paving our way going up the hill. So this is just authorizing me to apply for this grant. There is no loan component, 5% match, and we do the in-house.
5%?
Yeah, but we'll match it in-house with our labor.
Any more questions?
No.
I make a motion to pass C, resolution 2024-07. Granting Joey all of his wants.
I'll second it.
Counselor Proctor,
Aye.
Counselor Baseball. Aye. Counselor Weaver,
Aye.
Counselor Miller.
Aye.
Motion carried.
Item E.
Okay, the E under new business, discussion and possible action on approval of the creation of a temporary multi-jurisdictional hazard mitigation plan advisory committee. And
That was the mayor, but I defer to
Defer to-
Counselor Baker.
We can do it any way y'all want to. I got all of the, I gotta discuss.
Yeah, open for discussion.
Oh.
Open for discussion.
yeah, and I'll second it.
Counselor Proctor,
Aye.
Counselor Weaver,
Aye.
Counselor Baseball. Aye. Counselor Miller.
Aye.
Motion carried.
That whole packet, there's only been like 6 paragraphs that's changed in it. And all the concerns that everybody had, one of the people that wrote it said he would come in here and explain it all if you wanted to. Him and Wendy's the one that wrote it.
Yeah. Well, so we don't need the committee after all then, or you just,
Now, we have to have a public hearing on it. 'cause it never-
you have to have a public hearing for sure.
That's what we gotta do. And that's where I think we would have those two people come in and talk to us about it.
Well, it was clarified that a public hearing wasn't required. The lady that Wendy, when she presented, she stated that all the other municipalities didn't have a public hearing.
Well, we have all the material for sure. 2 times.
Rio Dosa had one on it and nobody down here knew about it. Nobody was invited down here from it.
And it's already been through Homeland Security and FEMA,
Like 4 other municipalities.
right? And those,
And all the other municipalities have gone for
So
it.
what we've done is looked at it, John, and I've looked at it. And Councilman Labor's looked at it, and we kind of conversed a little bit, and to keep from a rolling quorum. We haven't.
You didn't
passed that.
converse with anybody else?
No, well, with my wife.
Yeah, never
But
mind.
anyway, and what we're looking at, if we do find any improprieties in there, that we could solve it very easily by drafting our own in a resolution and add to that, like our bridges, cleaning so far back from our water tanks, our wells, bump heads and things like that, that resolution would protect us. And then in the next 5 years, when it come back up again, we could implement it
then, right?
Then.
Because everything that's here has done been cleared.
Right.
It is all, y'all gotta do is look at it.
We're looking at probably 10 months, 2 months to a year turnaround.
So let me make this suggestion, because you're wanting to resolve your public hearing issue, right? And even though Rio Dosa had one and it was advertised to City of Rio Dosa and Rio Dosa, your concern is that the citizens of City of Rio Dosa Downs didn't know about it, didn't partake.
Well, or
Well,
what
either way.
divided, whichever, it doesn't matter.
Right. So my suggestion would be that,
Committee or no committee?
if you've got, no committee, if you've got the people that can come and explain it, I would put it on the agenda as a public hearing, discussion and possible action on adoption. And at that public hearing, let those people make that presentation. That's gonna save a lot of time.
Okay,
Does that work?
Did you want to do it the next meeting?
well, we gotta go through this to find out when the next meeting is gonna be.
And make sure he's clear, he can come that
Yeah.
day.
Oh, that's right.
Appointed for,
Okay.
well,
He was here no, never was here.
public hearing for the next regular meeting.
Which would be the same meeting that y'all are gonna hear make your decision. about
On the
Hanging Stone.
20
Pretty lengthy.
On the 20.
So you may want to do the second meeting of March.
Second meeting of March.
And that'll
Do we
give you
have
time
to
have
vote
it.
on?
That's what it is. It's.
It's the second meeting, it's gonna be a workshop.
Well, if that's
The
the
first
case, it'll be
meeting.
the first meeting of April.
No, there would be the second meeting of April because if they do, approve the.
We do a workshop,
It'll be
okay,
the first
a
one.
workshop,
workshop is the first meeting.
And then you can still do the second meeting.
right, still do the second meeting. And Joy can't say nothing in that one, have all this stuff that we gotta approve. Well, we won't be having this,
I got opposition to this whole situation.
we got.
You guys realize I try to hire somebody, I'm gonna hire every one of them under an emergency if y'all pass this. Because if not, I can't wait a month to hire an employee. Unless I can put it on your special meeting.
You want to bring that discussion?
I
up
will
when we get
get
there?
later.
I've got a question for John.
Yeah,
On a workshop, John,
Pardon?
when we have a workshop, is there any way we can also state there might be some action items?
Not in a workshop.
Not in a
You have to come out of the workshop and go into a.
But you can do it.
Handle.
Okay. Joey, did you hear that?
Yeah.
Okay.
That's clear as mud.
We have to have an agenda, that's why you can't do it in a workshop.
Right.
You can come
Has an agenda.
out of the
But
workshop and.
but you gotta have an agenda on the Open Meetings Act. You got an agenda to take action on Joy's hours.
Yeah.
Or you can do it on an emergency hour and get them.
Are you that hard to work for?
No, but we'll talk
Getting
about this.
employees.
I'll tell you about some stuff. around
His
this.
concerns are serious. It is a,
If we try to hire somebody, if I interview somebody today,
Can we wait until the next agenda item?
John's gotta keep us on track.
Okay.
So for this specific item, what are we doing?
I think that they're gonna, if I may interrupt, have a public hearing and action item on the second meeting in March.
In March.
On the hazmat deal.
Yes,
On the
sir.
hazmat. You want to make that motion then?
To not form the committee and to go ahead.
Okay, I'd like to make a motion to not form the committee and have an open hearing at the workshop.
No, the
A
March.
public
meeting.
hearing,
Public.
on the last meeting in March and provide that action may be taken for adoption after the public hearing.
I'll second that. Okay,
You got it, Ally?
Yes. Counselor Proctor,
aye.
Counselor Miller,
aye.
Counselor Faber,
Aye.
Counselor Lacewell. Aye. Motion carried.
And we're going
We're
to,
gonna need to deal with your beautification because we didn't.
oh,
Second.
that's right.
Right.
Okay.
Item G.
No,
Oh, yeah.
Item F.
F, we didn't vote on it. Okay,
Sorry,
F
yeah.
is discussion
Okay.
and possible action on approval of Ruidoso Downs Beautification Committee amended bylaws. And I was asking to have more time to work on the bylaws. If not, just postpone. And if the 25th is gonna be too busy, we could postpone it actually into April.
April.
Yeah,
Why don't you pick a date?
yeah,
Everything's just gonna be ugly till then?
the second, well, we'll just have a little more time to get it right.
I think that we,
First,
April, what's the,
first action meeting in there.
in April, the second Monday, fourth Monday, second meeting in April. That way I can get George to put two on the bylaws.
the 22nd.
Okay, the 22nd of April, okay.
I move that we postpone the approval of the beautification committee amended bylaws until the city council meeting in April.
Yes. The
Second.
22nd, okay. So that'll be postponed till April 22nd.
Second?
Mhm.
Not March 25th no more?
No.
No,
Do we have a second?
Second, I second.
Oh, you seconded.
okay.
Counselor Proctor,
Aye.
Counselor Lacewell.
Aye.
Counselor Faber,
Aye.
Counselor Miller.
Aye,
Motion carried.
April what?
22nd.
Okay, item G, isn't it?
G, all right, we're going on to G now. Oh, we're almost done. Discussion and possible action on approval of the city of Ruidoso Downs certificate of records destruction. I can't even say that. Destruction, 2024-001. Okay, may I have a motion?
I think that we open discussion on this.
Okay.
Counselor Proctor,
Aye.
Counselor Miller,
Aye,
Counselor Faber,
Aye.
Counselor Lacewell.
Aye.
Motion carried.
So,
go ahead, Jody.
Alan, would you explain the retention schedule, the way it's set up now and how our YouTube videos are destroyed right after the minutes?
So it was voted by the very previous governing body to go ahead and get rid of the videos as soon as they were approved. And now this specific certificate will allow the videos to stay on YouTube for 2 years. No more than 2 years.
Is 2 years enough? Do the counselors feel like I'd
We
kind of like
can't
to
do
see
it more than 2 years pursuant to resolution 2018-20 and pursuant to the league's update when it was updated back in December 3rd, 2020. It specifically has that verbiage. No longer than 2 years.
The state says we can't keep them longer than 2 years. Okay, and so this certificate here is saying you will not be destroying any of these records for 2 years.
Correct. The minutes, not the other ones. The other ones are up for destruction.
The YouTube videos,
Yes.
John, do you think, and your expertise on this, do you think that's long enough to?
No, maybe I'm stupid, but I think 2 years of retaining YouTube videos, if anybody wants to watch them after that.
That's
Plenty long enough.
Okay. Just thought I'd get your opinion.
That's fine. I think 2 years is plenty of time.
So I'm missing the wording here where it says that we are not going to destroy YouTube videos for 2 years. I saw on the schedule where it says anywhere from a minute there approved up to 2 years, but I want wording that says they will not be destroyed for 2 years.
See, I think it's down on the bottom where it says meetings and recordings.
No, I'm looking at the certificate.
The records retention says after minutes have been transcribed and accepted at the next regular meeting, but no longer than 2 years after the meeting date.
And that's the verbiage on the schedule. So
Right, I see that, but
this is the.
it was never explained to us when it went past through last year. I mean, I was here. We didn't know anything about the fact that the YouTube videos were going to be destroyed. And it was a big shock to the community and to myself as well, especially when I heard, oh yeah, well, you voted for that. And I was not explained to me that way. So it still says the same thing on this retention schedule of after the minutes have been transcribed and no longer than 2 years. I want this certificate that you're talking about to say they will not be destroyed. State statute. That's the verbiage they have.
We can keep them for 2 years.
Yes, that's what we're saying. We're gonna keep it for 2 years.
Yeah, but
That's
I
the
want that in
verbiage.
writing, that they're gonna be there for 2 years.
Can you change?
That's
Amend it.
legal. That's up to legal because.
Well, so it was
You never
always,
do it.
it was always that way, Ally, and you still just destroyed them after 2 weeks. Even though it says that.
Are you reading it?
So that.
So let me maybe take a pause here and just say, the purpose of this action item is to undo that. So we don't need to revisit that issue. And this is to keep the YouTube videos on up to 2 years, which is required by state statute. So I would, if that doesn't happen, bring it back before council. This is a mandate from the council to keep the YouTube videos up for 2 years as provided by that.
Okay, so the way it was voted on last year sounded a lot like it does here. The attached records will be destroyed. And it's so broad where it says anywhere from 2 weeks to 2 years. And I want it to be more specific that they won't be destroyed any sooner than 2 years.
The last certificate, we took before the last governing body, specifically stated after. It had nothing, no other verbiage. It was after. The minutes have been approved. So we only took the first few words. And this one.
So Ally,
The last.
in an effort to try and resolve this impasse, because the intent of this is to keep them on for a period of 2 years, right? So to allay Councilor Lacewell's fears, after minutes have been transcribed and accepted at the next meeting, because this pertains to meetings and recordings only, audio and video shall not be destroyed sooner than 2 years. Can we do that? All right.
All right, so are you gonna do a new certificate?
We don't,
But she can-
it's not the certificate that we redo, it's the attachment.
Okay. And so we'll be passing that next time.
No, well, you can amend it now.
You can
You amend it now and then you approve the certificate as if.
Okay.
The amendment.
Go ahead, Jody, and amend it.
Wait, I'm not sure how to make the motion. Okay, I move that we approve the Ruidoso Downs Certificate of Records of Destruction 2021 so that the audio and video recordings will not be destroyed earlier than 2 years.
I'll second that. Oh, you
After the
did,
meeting date.
After the.
after the meeting date. Okay, okay.
And then Miller seconded.
Yes,
Counselor Proctor,
Aye.
Counselor Baber.
Aye.
Aye.
Counselor,
aye.
motion carried.
Hey, we have one more. H, discussion and possible action on approval, resolution 2024 06, a resolution establishing the city of Mendoza Downs governing regular council meetings and workshop meetings.
I move that we open this for discussion.
I'll second.
I'd like to add some information. Counselor Proctor had mentioned to me that he would like to see the workshops and the change in the council meeting times. That was probably about 3 weeks ago or more. I thought about it for 3 or 4 days. Again, that was a couple of months ago. I instructed the city clerk to put this on the agenda after I thought about it and did some checking and this kind of thing. It sounds good to me.
Okay, roll call. Counselor Lacewell? This is just for the discussion, yes. Aye. Counselor Weaver?
Aye.
Counselor Miller?
Right.
Counselor Proctor?
Aye.
Motion carried.
Okay, regular meetings, unless business before the city council dictates otherwise, the governing body of Mendoza Downs shall conduct one city council open meeting at 5:30 PM on the fourth Monday of each month in the council chambers, the Hubbard Room. However, when that Monday is a city holiday, that meeting will be held on the next business day. Paragraph 2, workshop meetings. The governing body of the city of Mendoza Downs shall conduct one city council meeting, open meeting workshop, at 3 PM on the second Monday of each month in the council chambers, the Hubbard Room. However, when that Monday is a city holiday, that meeting will be held on the next business day. Purpose of these monthly scheduled workshops to allow the council to explore various items that would be presented for the agenda at the next regular scheduled council meeting. The department director will be asked to attend to voice their needs. Now, I did tell the mayor, if this doesn't go through like we think it's going to go through, or we plan for it to go through, we put it on the agenda and take it right back to where it's at and have 2 meetings a month.
I will verify that statement. You did say that.
What I said. So that's something that I'd have to convince you three to look at, but I asked for this to be approved now.
I noticed that what you read was amended from what is in the paperwork, and I would move that we accept your amended version that you just read as you stated it.
Is that not what? is in
I
the
just thought he
packet?
just read
You
it.
got a
That's in
copy
the
of it?
packet. That's the resolution.
Yeah.
You read off the resolution. I think he read an amended version.
Yeah.
That's what's in their packet. I'll have to look, because that's not what.
Did we, Counselor, I did that by memory. Did we get that pretty close to what you had said?
That's what I read right there is what we're asking for.
So,
Okay.
the amendment would be that, as it's stated in this packet, the purpose of these workshops is to facilitate question and answer for an upcoming agenda. Whereas Councilor Proctor read a different purpose for these workshops. And could you read that again, Councilor Proctor?
The governing body of the city of Mendoza Downs shall conduct one city council open meeting workshop at 3 PM on the second Monday of each month in the council chambers, the Hubbard Room. However, when that Monday is a city holiday, that meeting will be held on the next business day. The purpose of this monthly scheduled workshop is to allow the council to explore various issues and items that would be presented for the agenda at the next regular scheduled council meeting. Department directors will be asked to attend to voice their needs.
Right.
I apologize.
That's an amended version, and I like it. Can we all get a copy of that?
Yeah, you got it. You got one. He's got
Oh,
one.
is
She's
it?
got one. Mayor's got one. John got
Is it this one?
You got one?
No.
Oh,
No,
Where did you amend it?
that's it right there. 1 and 2.
Or did you amend it off of the one that we had on the package?
off of this one.
Yeah, that's it.
With a different one? Yeah. Did you give her a copy of the amended
Yeah,
one?
yeah, she got it.
Okay.
You wanna see this one?
I apologize.
And so I've made a motion that we accept the amended version that Councilor Proctor just read.
Okay, I second, but I still need a discussion.
Oh, okay, about this.
Yeah,
Mr. Joey,
there's a lot of stuff there.
that's what,
Comes up with grants and other things that I can't wait. Say that means.
to the end of the month.
That's 5 weeks till I get.
Till the next one.
I believe that we can schedule a workshop
That's
and
what I want to
schedule,
know.
and
But
schedule.
but the workshops, if it's legal for us to put it on the workshop, it's fine. If you're wanting a special meeting, that comes out of my budget to pay y'all for that special meeting, and how many can I afford that?
No, we can tag it onto.
You got lots of money.
Yeah, right.
Workshops are just for this purpose. The purpose of a workshop is for discussion.
Right.
So the problem that you've got in the current iteration is that it says Rio Dos Downs shall conduct one city council open meeting at 5:30 PM on the fourth Monday, okay? So that's word shall says that that's what has to be. So you can change that to may conduct one city council meeting on the fourth Monday and other meetings as called. My concern is that I don't want to, we can't get into special meetings because then that's extra money, right?
So if we change the word on the first, the ones in May.
We're trying to put the horse out here and then push the cart up to him.
Yes,
The mayor has hiring power.
He does.
And if Joy comes up and says, Mayor, I'd like to put this man to work, we need him tomorrow. The mayor approves it, he goes out and he gets paid.
And it's
Then
conditional.
that's not conditions.
That's not so true.
Yeah.
Huh?
It's, if you read because of how we're set up government wise,
Right.
it's the emergency hires for the health, safety and welfare of the city.
Right.
So basically, well, I will say every one of them is a
I think all of
emergency.
your.
Okay, then you go say,
But I don't want you arguing with me that it's not an emergency, you know, I mean,
Joy, if you come up there and you got somebody you want to go, I know it, I used to work, I used to how hard it was. If you've got something that you want to hire somebody, you present that to the mayor. Hey, this is an emergency, I need him tomorrow to go to work. I don't think he's gonna balk and squirm over it. I think he's gonna tell you, hire him when it comes before the committee or the councilors, then unless he's got a police record that long.
That's what he's trying to tell us. He can't do that.
that makes it really tough. 'Cause
Yeah.
You done signed off and hired the man for a policy, I mean, yeah, he's on probation, I guess.
Well, he's gonna be on probation.
I just want clarity from y'all that that's how it's gonna be.
The only issue that you're gonna have, I think, is that person is gonna say, okay, let's say it's 4 weeks, 3 weeks out, okay? So if it comes back and you end up in personality issues, somebody says, well, I like that guy. He was dating my daughter, dating my niece. No, I never liked him, okay? So he's worked 3 weeks without getting approval, so he's tossed out for whatever reason. Then he's gonna say, well, I'm not so sure I wanna do that, right?
All that I do, I physical, I drug test, I buy their uniforms, I mean, they're $700 per employee. And, you know, it's, right now, it's hard to get employees, so when I get one, grasp, I hope they work, but
Don't they have to go through the background check and everything like everybody else does?
but they're hired before usually or right.
Before it ever gets in.
I've had that before too. Well, oh, your guy's driver's license is not good. We need to look into this.
Well, then, let's get the police department, do it a little bit.
The hardest thing is just waiting. Like, I'm gonna interview a guy Wednesday this week. First application we've had in 2 years for this position. It's a young kid, doesn't know nothing. So I'm gonna interview him and I'm gonna choose him or not choose him Wednesday. Then I gotta wait a couple of days, get his physical and his drug test. If we do the 5 weeks, that's 5 weeks before. So as long as it's okay that the mayor signs off on it, then I'm good.
I think that works.
The only
Fine,
thing
we'll
is, if I could, well then, why don't you wait until we approve it before you order all the uniforms? I worked down there 6 months before I got a uniform.
Right.
You know that.
Yeah, oh, yeah.
I
John,
would,
what I.
go ahead, I'm sorry, go ahead.
I thought you were done. Anyway, having the workshop, you have to have an agenda, right? Okay, when he turns in whatever he has for the workshop, he could also say, I need action on an item. No,
But
you go
have
from
to
the
go out of your workshop and
into a meeting.
discussion.
Then that gets complicated too.
No, you
Yeah.
can't call it.
That's what, I'm just worried about what
If
you're
it's on the
saying and what I'm saying about as much
That's
stuff
what
as
the
you got that comes on the agenda.
Well, right now, we'd be at 9 to 10 o'clock.
Exactly.
Well,
Right.
the village has a thing
I
that
think,
they don't pay them every time. They used to pay 500 a month, and no matter how many meetings you have. I don't know if they still do.
I think that
Another ordinance.
what I just mentioned is pliable, is pleasable, and I think it'll work. Is that the mayor has the last say so on who's hired, who's not hired. That's it.
As a temporary hire.
Right. Now, if he goes under works conditions and goes to the mayor, doesn't have to talk to any of us, goes to the mayor, this is what I'm looking at. The mayor can say yes, or you say no. If he says yes, then he doesn't go and spend $500-600 on uniforms until it comes before the council, have it approved. If it, I mean, a uniform, you can hold back on that. What do you hold, 3 weeks?
It all depends. I mean, honestly, if you want to be technical and honest, the day the man starts working, if he works in sewer, water, or wastewater, it is required by law. That
I just think it's safety with uniform.
But yes, Terry, I work with Terry. I mean,
Could the
uniform
mayor,
didn't happen for a long time back then.
could the mayor roll us?
The same thing.
But it's still back to my deal.
Me personally, I don't like the 2 meetings. I love the fact that I can have a workshop and talk with you guys that I can't at the meeting.
Yeah.
Okay, tell me this, what part of the month is best for you?
The very last week of the month, because everything comes up for us on JUB and all that for the first
So what about the 5 weeks till the next meeting?
stuff.
That's what I'm saying.
I'm saying, I almost would rather have 2 meetings, but let's.
If we move to, if we move,
Try and see it, so yes.
if we move too slow, what happens is this guy says, take with it. I'm gonna go to Carrizosa. Or in other words, we lose guys that,
Yeah.
they figure, heck, that
There are no applications right now, so if you get one, you better jump or
Yeah.
hired them down there.
Yeah. Yes, ma'am.
Wouldn't it be possible, there's this term, there might be a meeting of a possible part. If Joey, if you knew in advance, and we're getting ready to have a workshop and you know you wanted to hire somebody, wouldn't it be enough time for us to post this as a workshop at 3:30 that will turn into a city council,
If needed.
if needed? When the
5:30,
workshop
not
is
spending any
over.
more money, you're just stretching it out.
But if he already knows before a city council meeting that he's gonna present somebody for hire, and you know now before a workshop, you've got this person you want to hire via special. We could put it on the agenda as a workshop that's gonna roll over into a meeting and change this wording.
Let me make this suggestion. Why don't we leave it like this for the time being, and then if we run into issues and problems, because it's hard to think of all that stuff and how it's gonna work in advance. And this is a solution to some of the problems that we've had, and we're not gonna solve them all. And I hope Joy's able to have the mayor's, emergency hire a lot of people.
Yeah.
And I just want to make one thing quotation, when I talked to Joey about it, way back, before I was even elected. It's what I was thinking about. I got no problem with it.
Well,
No, I don't. I told you from day one.
that's before he
5:30
got to thinking about it.
Oh, you got to think more thinking about
Well, the 5:30 is what gets it, because every community in Lincoln County goes from 10 o'clock in the morning till 2 in the afternoon. You know, I've been here long enough, and you've been here, that everybody wants to claim foul at 5:30. We need to be here, because 5:30, nobody ever showed up. We got more people here today than we've ever had here.
Okay, what, I didn't interrupt you, but what I did tell the mayor was 4 or 5 months down the road, we don't have nobody coming to the meeting at 5:30, then we'll take it back, put it at 2 o'clock, and that's what we'll do. And that's what we said.
I'll
Okay, so-
verify he said that.
The resolution, the way you just presented it. to
I
us,
can,
We're just gonna go ahead and vote on it. And I have one question for Joey. If you hire a bunch of people, let me know, because the next time I mix in the roles.
Well, I only got one open position, so.
All right, so I've made a motion to accept this resolution as amended by Councilor Proctor. Did someone second?
I did.
Counselor Bieber,
Aye.
Counselor Miller,
Aye.
Counselor Proctor,
aye.
Counselor Lacewell.
Aye.
Motion carried.
Does anybody object to us adjourning right now?
Hell no.
I'm ready.
Can we take that
So long to
back
say
out?
it.
I'm ready. What?